Honor, it is not relevant, and it is blatant character.
Okay. What about the state's observation? And you touched on it very lightly and moved on, and I get why you moved on. But an element, when I think about aggravated stalking, the rudimentary and insufficient perspective is it's effectively a status offense. Like if you show up where the possessor of the TPO or the TRO is, you've committed ag stalking. As a co-author of the revised pattern charge for aggravated stalking, I was educated by my peers and by looking at the old pattern charge. The state has to prove it's an element that Mr. Bryant, if he did violate the TPO, he did it for a specific purpose, and that purpose is to harass and intimidate. It's not just he was driving by and Ms. Thomas happened to be there. That wouldn't constitute a violation. And it's because of that that I think the state is going to want to get, it's what they've said, they want to get into one or more of these prior difficulties to show that there's not an innocent explanation, or if Mr. Bryant should choose to offer up an innocent explanation, there is good reason to believe beyond just Ms. Thomas's word that I could tell he was there to harass me or intimidate me, that in the past he has taken steps to harass or intimidate Ms. Thomas. So I guess I'm pushing back a little bit on the relevance. I hear you that the only allegation of physical violence or conduct in the case in chief is against the daughter and not against the mother, the ex-wife. Are you exes now?
Soon to be.
Soon to be. Okay, so wife, legally still wife. That's where I'm wrestling with it. I think there is some relevance. There's prejudice, but of course, it's not a particularly favorable balancing test for the non-movement because it is substantially outweighed by undue prejudice.
I understand where you're going, Your Honor, absolutely. But I think that would be putting intent into Mr. Bryant's mind on while he allegedly dragged her around the house while she was pregnant. You know, that's the state saying that that was for him to intimidate her and to harass her. That's not how the aggravated assault are listed, and it is not part of our elements in an aggravated assault. The defendant pushed her into bushes and stomped her is not exactly harassment or intimidation. The allegations are exactly what they are. He pushed her and he stomped her. The state is going to try to put intentions of why Mr. Bryant did that he did this with the intent to intimidate or harass, which is speculation at best. So if these were, he pushed her, stomped her, and, you know, was verbally saying things, then I would agree with you more, but they are, you know, are not. They're allegations of aggravated assault, maybe sexual battery in March of 2020. They can assume all they want what Mr. Bryant's alleged intentions were to harass and intimidate, but then we go to speculation. Then we have a speculation argument.
Okay. Mr. Whitenauer, talk to me a bit, please, about the concern that Ms. Primovic has raised and how these prior difficulties relate to the harassing and intimidating element of aggravated stalking.
Yes, Judge. So all of these incidents are a part of a pattern of harassment and intimidation. I don't know that there's any other way to describe the prior difficulties that are listed in this notice as anything other than intimidation by violence. While pregnant with their firstborn son, Bryce Bryant, that the defendant dragged her around the house by her hair. Certainly that was not a loving act. That was an act of intimidation by violence. People don't commit violence typically to show love. They do it for nefarious purposes, either harassment or intimidation. So I think that is fitting. I think pushing someone and stomping or kicking them is intimidation.
So let me pause you. Let's take the 2015 incident.
Mm-hmm.
You've talked to Ms. Thomas. I haven't. If that's coming in, you'd be able to put some context around it. It wouldn't simply be you ask one question. Did in 2015, Mr. Bryant push you into bushes and stomp on you? So you'd be able to say, well, what was going on? So you're more familiar with what led up to each of these 4 allegations. Do they fit, as you understand Ms. Thomas's expected testimony, into yeah, we were having an argument and this was his way of intimidating me, of shutting me down, of, I'm not putting words in your mouth or hers, but if you can maybe provide a little context in particular for the 3 more recent ones, I'll be better able to evaluate, because I'm mindful of Ms. Primovich's concern, which is if you were limited to, I don't think you would be limited to the bare facts of the incident, which you would if it was only coming in through a police report or something, but you'll have a live witness who can be cross-examined. Ms. Thomas will be able to talk about, well, here's what was going on. And he caught me on my phone. And he said, if I ever see you on the phone again, texting that guy, I'm going to break your nose. I'm making all this up. Well, that's intimidating. Whether it's harassing or not, I mean, people can quibble, but what is your understanding of the context that we would hear from Ms. Thomas about the different events? If you can do that in a nutshell. If that's a 30-minute presentation, then I asked a bad question.
I'll try to stay under 30 minutes, Judge. So in my conversations with Ms. Thomas, it's my understanding that during their almost 18-year marriage, that there was not a month that went by without Mr. Bryant inflicting some sort of physical or verbal violence toward her, and that this was part and parcel of a way to keep her oppressed, to keep her dependent upon him and scared to break out of that violent relationship. I will address these other incidents, but I think what of all of them, the one that most highlights this pattern would be the March of 2020 incident. She would testify, Your Honor, that that day that she was preparing to go to work, that she was braiding her hair, and that while she was attempting to leave the house, that the defendant tried to prevent her from doing that, was trying to prevent her from getting out of the house and going into the community, and that he touched her all over the body in an unwanted manner, both her breasts and buttocks, and that this had occurred while she was still trying to get into the car and back down the driveway and get out, and that he continued to try to prevent her from leaving. So this is a part of him oppressing her, harassing her, stopping someone from going to work. I don't know how else to describe it, but harassing and intimidating. That this was what he did to keep her down, to keep her oppressed, and to keep her under his control. And so all of these are just part of that. Physical violence is part of that pattern to keep her under control. I mean, that is what DV is controlling the victims, whether female or male. And so he's controlling her movement here. And in February of 2020, he's controlling her communication. In 2015, there was an argument outside of the house. And she doesn't remember that argument. It was in 2015, but she does recall that out of nowhere, in the course of this verbal argument, that he pushed her into the bushes and began to kick her. And she does remember that as a result of that assault, that she injured one of her ankles and had to hobble around at work afterward. That physical violence is part of that campaign to intimidate her and to harass her. And I did ask her, I mean, to make sure that she was going to be able to meet the elements of this offense, that these behaviors placed her in reasonable fear and created emotional distress for her.
Let me ask you a question, please, about the event number 4, March 2020. The description is of unwanted contact, but as Ms. Primovic described it, it was sort of the reaction I had as well, that it would, you've clarified it some. It sounded almost like it was a sexual advance that was unwanted, but what's written is she's trying to leave and Mr. Bryant is trying to prevent her from leaving. But the description is peculiar because it doesn't sound like he grabbed her, he held her back, he pushed her down, but he's touching her in places that I don't know that one would normally touch if you're simply trying to restrain or keep someone from leaving. Well, how does Ms. Thomas explain, as you understand it, what was going on?
Well, I think that there were several instances of unwanted touching. If the court has concerns about that that sexual touching, that sexual battery being more prejudicial than it is probative, I'm fine in limiting her testimony to the fact that he was physically trying to stop her from leaving. I don't have a problem with that. It still would be part of that pattern of intimidation.
Okay, got it. Thank you for clearing that up. Ms. Primovic, anything more you want to get out from the defense perspective before I enter a ruling on the prior difficulties?
And Your Honor, with the 2009, and we just want to go with the lapse of time, how long ago it was. So
Okay.
2015 is, but definitely the 2009.
Okay,
2020 for lapse of time argument only. The time seems to be correct, but we still stand on our initial arguments.
got it. Okay, thank you. So I will allow the state to inquire of Ms. Thomas about incidents 2, 3, and 4. Number 1 is somewhat remote. I appreciate the case law. I don't know that it is absolutely too remote, but it is also in some respects much more prejudicial because there was the potential that Bryce could have been injured by that contact and that conduct. And given its remoteness, the increased prejudicial value, I think, tips those scales that I do find that the undue prejudice, she was pregnant at the time, substantially outweighs the probative value, especially because the other 3 are coming in and they are more recent in time and seem more consistent with what happened, what's alleged to have happened in the case in chief. So I will allow Ms. Thomas to testify about the 2015 incident and the 2 2020 incidents. I'm going to take you up on your invitation on the March 2020 and ask you to have Ms. Thomas at least initially describe it as he was assuming this is her truthful testimony, Mr. Bryant was physically restraining her from leaving, grabbing her, pulling her back. And if the defense opens the door by saying, oh, how was he grabbing you or where, she can answer that. But I'd ask you not to lead with that. Not because it's a misstatement, it confuses it and it makes it sound like maybe it was a different channel of conduct that doesn't seem to be the theme of this case. And it makes the testimony unnecessarily prejudicial. It's going to be prejudicial. I mean, I want to be clear. I don't think any of this is helpful to Mr. Bryant. That's why there's an objection to it. But I do find that there's a proper purpose. I think that it is relevant to Mr. Bryant's intent in the case in chief and his motive, what he thinks, why he might have done the things he is alleged to have done in April of 2021. I think the state bears that burden, especially given the elements of aggravated stalking. I don't think the jury will be confused as to whether Mr. Bryant is on trial for aggravated stalking and simple battery against Elizabeth Stewart. Is it Elizabeth Stewart or Elizabeth Bryant?
Judge, her name is Elizabeth Bryant. It's a scrivener's error in the indictment, and I did include a proposed jury instruction regarding that.
Okay, but it is Elizabeth Bryant who would be the daughter of Ms. Thomas and Mr. Bryant.
She is.
Okay, all right, we'll work through that at another juncture. Anyway, for those reasons, I think that there is a proper purpose. I also find that for the 3 later events, the probative value is not substantially outweighed by undue prejudice. I also don't think we'll have a trial within a trial. Ms. Thomas is going to be testifying anyway and will be subject to a rigorous cross-examination. We're not bringing in extra witnesses to cover that. And finally, I think the proof by preponderance is easily demonstrated through this proffer. And the only way the jury will believe it would be if they believe Ms. Thomas, who will be testifying. So I'll allow those 3 in. Question though, Mr. Whitenauer, you twice at least in describing the relationship between Ms. Thomas and Mr. Bryant said, and these are now my words, many times Mr. Bryant did X. There's a long history of Y, X and Y being Mr. Bryant doing bad things to Ms. Thomas. How do you envision that coming out in testimony? Because I don't know, and I want the defense to get on the record their concern, whatever it may be, that testimony of basically there has been perpetual prior difficulties in this relationship. I think it would be appropriate for Ms. Thomas to say, It's been a difficult relationship. It's often been violent. She'll then talk about 3 instances that are specific. I don't think that's inappropriate, but I want you to be cautious about what you ask that might prompt Ms. Thomas to suddenly provide a litany of things for which, I mean, you don't need to provide notice. That's the complicated part with prior difficulties. But if you think she's going to get into specifics rather than, I can't tell you how many times we had an argument where it ended with him hitting me. I think that the way 404B is written, that is an allowable statement. And clearly the defense is on notice that Ms. Thomas is going to be talking about how tumultuous the relationship was. But I want to make sure you weren't planning on saying, and these 3 instances, were they 3 out of 1,000, or at least understanding how you were going to navigate that, so we could get basically an oral motion in limine if there's going to be one from the defense.
Yes, Judge, I understand the court's concern, and it is accurate that while interviewing Ms. Thomas, that when she discusses these incidents, she sometimes would conclude with, words to the effect of that was typical, or that wasn't anything new. Given the court's comment about how comments like it was a difficult relationship or has often been violent, I think those sort of comments that she's made to me are consistent with what you were thinking might be appropriate. But I will speak with her and make sure she's aware that we'll be focusing on these 3 incidents and not bringing up other specific instances that haven't already been raised. I will say that for her testimony in general about Mr. Bryant coming to the house, she made a comment about how he was cursing at her and at other people in the house, and she has made comments like, he would always say things like that. So I do anticipate that sort of testimony, but I'll make sure that we are limited to these incidents.
Okay. Well, and I think if you are asking Ms. Thomas about what happened on April 30th, 2021, and she is then saying that is something that has happened before, the language used, if she says he was menacing in the way he walked towards me, I think 1, it's relevant, 2, it's admissible, prior difficulties, and 3, it's relevant because it goes to this element of what was the purpose of being there and the impact that it had on the alleged victim. So I think that's all right. And it doesn't sound like you're going to say, well, give me 5 examples of how something like that happened before. You've got the 3 that you can explore in some detail, and otherwise it's going to be, and this was the nature of our relationship.
That is accurate, Judge, and I will speak with Ms. Thomas about that.
Okay. Ms. Wood, concerns, further guidance you want from me to Mr. Whitenauer on that topic?
No, Your Honor, I think that was sufficient. Thank you.
Okay. Do you want me to tell the jurors in my opening instruction that they may hear some evidence about other acts that Mr. Bryant allegedly committed? He's not on trial for those, and they should consider them for limited purposes only, or stay away from that until Ms. Thomas testifies?
John, you're going to mention it in opening, I'm sure.
I will.
Yeah, so we did.
Okay.
He's going to mention it in an opening, and we was going to ask for some limiting instructions, so that would cover that. Thank you.
Sure. So I plan then on giving a limiting instruction 3 times. Once would be in my opening comments to the jury in just a few minutes. Then would be just before Ms. Thomas testifies. And then finally, obviously in the written charge that goes out with the jury. So they'll have that physically in front of them. All right. Anything else, Mr. Whitenauer?
Yes, Judge. So when I arrived in court today, on the state's table, there were 2 documents. One is a family violence petition for temporary protective order, and the other is a family violence ex parte protective order. Both are dated April 15th, 2021. The state, to my knowledge, had not been submitted those previously. I assumed that from the defense. I hadn't had an opportunity to speak with them about it. But I would like to know if they intend to introduce those at trial, and if they do, if they have certified copies of them, And then also I'd be asking for some leave to go speak with my victims about it and to do some additional research. It might also impact what jury charges I suggest to the court. So I would like to address that.
Okay. And you said they're dated April 15th, 2021?
They were filed April 15th, 2021. Yes,
Okay. So that would be 15 days before this situation.
that's correct.
So if they are what they purport to be, and I assume they are, there were cross TPOs in place?
That's what this would seem to suggest.
Okay. All right. So Ms. Primovic, I assume it's safe to assume that those were documents the defense is providing to the state.
Correct, Your Honor.
Okay.
Upon speaking with our client last night, he brought these up. I'm sorry. He brought this up. He got us the certifieds, made copies this morning, got into this may come in. Don't know yet.
Okay.
Wanted to give the state ample time, you know.
Okay. But they're court records. I mean, they may not be easy to get to because.
Yeah, they're filed in Fulton County. They're here.
Okay.
I don't think they're on Odyssey.
They are if you have the case number.
They're in Odyssey. They're in
Okay.
Odyssey, Your Honor.
All right. And they are two separate TPOs?
One is just the petition and one's the order
Okay.
from him to her.
Got it. And you've got certified copies of them.
Yes,
So
Your Honor.
if you decide you're going to get into them, we're not going to have a wait. How do we know that's what it really
Yeah,
is?
we have
Okay,
certified.
good. So Mr. Whitenauer, at least the box of authenticity and foundation has been checked. You are free, both sides are free to amend the jury charges. You've submitted the basics that you want. Ms. Niles is actually at work now. Putting together a draft charge, but trials flow in funny ways. And so you may have something that you want to add, and that's not a problem. And if you think there's something that we need to talk about outside the presence of the jury concerning those documents, we can do that as well. I assume that they would be tendered either through Ms. Thomas's cross-examination, or should Mr. Bryant choose to testify, his direct exam and not through the officers or whatnot. But the defense just needs to flag with you when they tend to go into those.
Yes, Judge. I'm glad to hear that they're certified copies, and I understand that they certainly can work to have those entered into evidence through those witnesses, should they choose. But that they may attempt to introduce this into evidence certainly would change the state's position and how it would respond or present its evidence.
Mhm.
And so I would be asking for some time to prepare for that response. Cross TPOs is not something that's been raised previously.
Right. So when you say prepare a response, I'm not quite sure what you mean. I mean, we're going to go forward. I don't know who your first witness is. If it was going to be Ms. Thomas, that'll be a little complicated because I'm sure you want to talk to her a little bit about this and see whether she says, oh yeah, I knew about that. I just never told you, or I had no idea. It's possible that because of what happened on April 30th, 2021, she ended up not getting notice of this cross DPO. It was only 15 days apart. And I don't know. I don't need to get in the middle of that right now. I guess I just need to be clearer as to what you're asking for now.
Well, sure. I haven't had an opportunity to speak with Ms. Thomas about these.
Okay.
Really. Your Honor, both she and the daughter know all about this because they were served.
Okay.
So they could talk all about these priors, but they can't talk about her being served. And I would never question the state's credibility and representation to the court. But if she's hiding that from them, that's her problem.
Okay. It's clearly a problem. Whose problem it is between DA and Ms. Thomas, TBD. But I don't know how TPOs work. There's some evidence other than Mr. Bryant telling you that Ms. Thomas was served with it. I mean, like there's a signal. How do you know she was served other than Mr. Bryant?
The daughter called the grandmother and him and said, oh my God, we got served.
Okay.
What's going on?
And
So the daughter was full well prepared, who was also a witness on the witness list.
Okay. And that's Elizabeth Bryant.
Correct. Your
And you know this because Ms. Bryant told you, or because Mr. Bryant said, this is what Elizabeth Bryant told me?
Correct.
The latter.
Correct.
Okay. All right.
In their service, Your Honor.
Well, that's what I'm at. So I don't know.
In their service.
Okay. Is that something that's in the docket or? So it's sort of like a civil case. There'd be something from the sheriff saying we served.
Correct.
Where McBurney sued Primovic for Primovic's tree falling in his yard, there's proof of service on Primovic. Okay. I'm not doubting you. I wanted to understand the mechanism.
Thank
So
you, Your Honor.
independent of Mr. Bryant telling you, I know they were served, there is also in the record proof of service. Okay. How are we doing with jurors?
Was that silver lot?
Oh, there's no silver lot. I mean, can you park at the silver lot and get the shuttle? Oh, I thought it was like red and yellow. Silver lot. Okay. Who's that? Mr. Royster. Okay. I think he's our final regular juror. So, we need everyone anyway. Yeah, he's number 12, 32. Okay. So he should be en route. Okay. All right. So you've let them know. Please let them know we're ready. And all we're waiting on is Mr. Royster so they can mean mug him when he comes in. All right, so we don't need to be on the record right now. My civil jury last week in this Marta case had a father whose wife was like 9 months and 3 days pregnant, and they just had their kid. And this nice juror sent an email to all the jurors and my staff saying, here's our new baby son. They didn't name him Robert, though. I'm disappointed.
Do you have the certificate of service, Lacey?
Miss Bassett is looking for it.
Okay.
So now would be a great time to talk with Ms. Thomas while we're waiting on the last juror.
Judge, I just don't want to leave and then them being waiting on me. I'd have to go back to my office where she's waiting.
Okay, I'm just letting you know, it may be 10 minutes before this guy shows. It may be 1 minute. So you all navigate that, but I'm viewing this as a window when there could be that panicked conversation.
Bring them over now.
Yeah.
Okay.
From me? Oh. From me? Yeah, and he's not supposed to be there. I know.
So he could be sitting there for a long time. Where's your squad car? Go get him. How about the golf cart? Yeah, put the siren on, get down there in record time.
Go to the restroom, I'll be all right.
He's walking in the room.
Or Mr. White now he's only got 2 minutes instead of 27.
Okay,
Oh, yeah.
The Wi-Fi is having trouble today.
I saw that, Judge. I was
Yeah, which
wondering-
is, hopefully we don't have a ton of exhibits right away. But Ms. Hankins was eventually able to get in this morning, sitting here, so
Yeah, so far, so good.
good.
No, I think he was left.
We can still use it to get out cross violence.
Yeah, so-
Got you.
You see what I'm saying?
Because he was in jail because of this. Classic. Yeah. Yeah, but the real, why we need it, the relevance is for his story. The relevance of it. Yeah, right. She should have signed them both.
Everyone's ready? Great. Let me just add this one camera and we'll get going.
Which is why they didn't give it to you.
Excellent. Okay, Mr. White now, ready for the jury?
Yes, Chair. Yes, Judge.
Ms. Wood?
Ready, Judge.
Let's bring him in, please.
Ready to call Ms. Bryant?
Is this on?
It is?
Yes.
And what do you see on it?
Zoom
Speed
screen.
racer.
All the Zoom screens.
Just Speed Racer? Oh, okay. That's my little icon.
There's 11 of them.
All right, this now. Is it just this chair on it?
Yes.
Good. All right. I don't know that you all will need it, but the screen in front of the witness is a touch screen, so they can mark it up if you need someone to circle something on a photo or a document. We can make that happen. You're welcome. Thank IT. They may need your help back there. I don't know what's going on with Deputy Gordon. Hello.
Oh, no one wants that.
Pardon me? I didn't see, there's a little red dot. Oh, when they come in. Got it. Okay. Let's not do that. Thank you.
You're welcome.
Smart. Ms. Wood, is there a statement from your client that's coming in that you're aware of? A custodial statement?
Judge, it would only be whatever's on the body camera and it's prior to arrest.
Okay. I'm just looking through the pattern, the requested charges.
Well, so he is placed under arrest and he does make comments to officers while he's being, so he's placed under arrest, his arm replaced. His hands
Okay,
placed
we don't
under-
need to sort it out now. I
Okay.
just wanted to, Ms. Niles was saying, there are all these things about the statement of the defendant. We hadn't had a Jackson Deno anything. So I just wanted to make sure there wasn't a, let's sit down in an interview room. Here's your Miranda waiver, all that. That's not in this case.
That is not in this case, no.
Okay. And this is the case I'm interested in.
I understand.
All right, adjourn.
Gordon, you're having trouble in corralling these people to get a better deputy. This is like
Officers are present.
20 minutes to get them out here. Good afternoon, ladies and gentlemen. There we go. You all can be seated. Welcome to 8D. It's great to see some of you. I missed the remaining, we've got 14, so 46 people. I bet they're sad that they're not here today. But I appreciate you all being here. One of you got a little stuck, so we're getting started a little late. Tomorrow, hopefully everyone can be here on time because the cardinal rule of jury service, besides no outside research, which we'll talk about later, is we can't start till everyone is here. Each of you needs to see and hear the same thing. So we can't start and say, hey, we'll catch up, Mr. Royster, when he gets here. We need everyone to be here on time. But this was the first time, and we've actually been covering a bunch of things. We started a little early and only finished working through what we needed to about 15 minutes ago. So not a big loss because we'd have to work through that stuff anyway. Let me give you a few operational rules. Then I need to swear you in as jurors. Yesterday, you took an oath to be potential jurors, and in a moment, you'll take an oath to be actual jurors. A few logistics. There are no assigned seats here. So you could be comfortable in the seat you're in now, but after the next break, you should feel free to take a different seat. It actually is a helpful idea to sit in a slightly different place throughout the trial because you literally get a different perspective. The witnesses who will be testifying will be sitting right there, and they may be looking at the lawyer who's standing over there. So if you're up close in front, you only see the side of the witness. If you're further back, you might see more of the witness. Some witnesses turn toward the jury and testify, but you should feel free to sit where you want. The one request is if you're the first one in, walk all the way into the row rather than be the first one in and sit right there and just to climb over you. Second, logistics, masks inside the courtroom are optional. So if you don't want to wear a mask right now, you don't have to, but you are welcome to. I will never require anyone to remove a mask. I'll be asking every witness to remove his or her mask for testifying because it's really helpful to hear. But if that witness says, I'm not comfortable doing it, we'll work through it. And that witness will need to get really close to the microphone. When you're in the jury room, it's a group decision as to how you want to manage masks. That's a smaller space. But other than when you're deliberating, that jury room is sort of home base. You are free to fan out all the way down that hallway. It's a private hallway. No one else can be back there except you all and some judges and their staff. The one thing I'd ask is don't play the drums when you're back there because then my colleagues will come down and yell and say your jurors were real noisy, but you're welcome to go all the way down that hallway and spread out. We'll probably have one break today, mid-afternoon, because we're only going to go till around 5, and then we'll pull up anchor and come back tomorrow. But we'll break anytime one or more of you needs a break. It is real important that the moment you start to lose focus and just need to shake things out a little bit, we'll pause. And it may be as simple as everyone just stands up for a minute and moves around. But if you need a restroom break and that need for the restroom break is causing you to lose focus on what a witness is saying or what a lawyer is saying, then we should pause. Usually a break in the middle of the morning and a break in the middle of the afternoon plus lunch, which you should have already eaten, is enough to get through the day. But we'll accommodate whatever your needs are. And last things about the seats. It may be that one or more of you has a situation where you need to stand up every once in a while, bad back, bad hips, whatever it may be. And if you are that person, I'd ask that the rest of you let that person be on my left end of the jury box, because it does not disrupt anything for a juror who's on the end just to stand up for a second, maybe lean against the wall if you need to do that. It will disrupt if you're way down at that end and you have to get all the way down here to stand up. And no one may need that, but we certainly offer that up. With those logistics out of the way, I need all of you to stand up and raise your right hand. Do you swear or affirm that you shall fairly try the issue that is brought by, where did it go? This bill of indictment between the state of Georgia and Stuart Bryant, who is charged with aggravated stalking and simple battery, and give a true verdict according to the evidence? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? Okay, hands down. You are now all officially jurors. Congratulations. I need to talk to you for a few more minutes before I hand things over to the lawyers. We are about to start with the presentation of evidence and some presentation from the lawyers. From here on out, the way you get in and out of the courtroom is the way you did today. You go down that back hallway, buzz in, and report to the jury room. So you'll do that tomorrow. And if we go on into Friday, you'll do it Friday morning as well. And when you leave, you'll leave here by going into the jury room, and then Deputy Gordon will release you and help you get out of the building. We're going to go, like I said, till about 5. There's not an exact hard stop. There's not a bell that goes off at 5 and everyone says school's out. We'll see how things are flowing a little before 5. And if there is 15 more minutes from a witness and we could wrap that witness up, we might go to 5:10. But if at 4:50, I asked one of the lawyers, how much more do you have? And we're already at a natural break point, and the lawyer says, I have another 45 minutes. We may just stop a little bit early and pick back up tomorrow. Tomorrow, we're starting at 10 a.m. So you need to be here before 10. And once everyone is here, as close to 10 as we can make it, we'll get everyone out here and pick up wherever we left off today. If for some reason you're having trouble getting here, please call. If you don't have the number for my chambers, Deputy Gordon can give it to you. He can write it up on the whiteboard, 404-612-6907. I think it's 6907, but we'll write it down. But if you call, then we know not to panic. Hey, it's Juror 7 or it's Mr. Jones, and I'm stuck on I-20. Oh, okay. When do you think you'll be here? I think it'll be 20 minutes. Then we can let the other jurors know, and then we know what's going on. If we can't reach you, then we start to worry, and we may have to send deputies out to find you. And that's always awkward when the neighbor's like, why were there all these squad cars in your front yard? Because you went to Dunkin' Donuts and forgot about jury duty, and we had to come try to find you. I need to give you some preliminary legal instructions and a little bit of an outline of what criminal trials are like. But what I want to start with is about the notepads that you've got in your hands or in your laps. You are free to take notes if you want to take notes. You are not required to take notes. Note-taking may prove helpful because you will not get a transcript of witness testimony. When this case is over and you're beginning your deliberations, you don't get to ask Miss Rivers for like, hey, what were you typing down? Can't we get that? No, you cannot. You will need to rely on your collective recollection as to what each witness said and whatever your notes have in them. So for some of you, it may help to take notes. You may decide these are important points that are being made. I'm going to jot down that this witness said that. But you don't have to write anything down if you don't want to. If you are a note taker, please don't let the note taking interfere with your other senses as you process this trial. One of your jobs is to be determining the credibility or believability of the witnesses. And one way you do it is just by listening, and the person says the sky is red, and you're like, okay, this guy is not shooting straight to begin with. But another way people judge credibility is by watching how they answer questions. And if the witness answers questions from one lawyer, engaged with you all, making eye contact, and then the moment the hard questions come, the person stops making eye contact and there's sweat everywhere, that could tell you something. It may not, but it could, about that witness's credibility. You will miss all of that if you're buried in your notes trying to write down verbatim what everyone says. You'll kill yourself if you try to write down verbatim what everyone says. But feel free to take notes. Your notes are private, meaning you should not share them with anyone until you begin your deliberations. Once you do, you're deliberating, you're free to say, well, hey, I wrote down this. What did you write down? When the trial is over, we will take your notes and shred them. They will not end up in the record. They won't end up on the Drudge Report or anything like that. So feel free to write whatever you want in them. I'm going to talk to you in a minute about your role as jurors, my role as judge, and what the lawyer's role is in this process. Many of you have not been on a jury before, so your sense of what a trial is like and what jurors do is based on what happens on TV. And that's fascinating, and that's what sells eyeballs and ads and whatnot, but it's not really how it works in the real world. It's important that you follow my description as opposed to your expectation of what happened in Perry Mason if you're really, really old, LA Law if you're kind of old, or like CSI if you're not quite that old. Mr. Bryant is the defendant in this case, and he is charged in this indictment with 2 crimes. Crimes are violations of the law of Georgia. I'm going to read to you now the 2 allegations in the indictment. Count 1 charges Stuart Bryant with aggravated stalking, and the allegation is that here in Fulton County, on April 30th, 2021, Mr. Bryant did unlawfully, at a place other than his residence, contact Malika Thomas without the consent of Malika Thomas for the purpose of harassing and intimidating Malika Thomas, all in violation of a temporary protective order which prohibited this behavior by the defendant. Count 2 charges Mr. Bryant with simple battery, family violence. And the allegation is that here in Fulton County on that same day, April 30th, 2021, Mr. Bryant did intentionally make physical contact of an insulting and provoking nature with the person of Elizabeth Stewart. And I think the state is going to tell you that the name they meant by Elizabeth Stewart is Elizabeth Bryant, but what it says in the indictment is Elizabeth Stewart, who is the child of the defendant, and that Mr. Bryant did so by pushing Elizabeth Stewart. Those are the 2 allegations in the indictment. They are not evidence of guilt, and you should not consider them as evidence or even an implication of guilt whatsoever. It's simply how the state brings charges against someone. And to those charges, Mr. Bryant has entered a plea of not guilty. He sits before you with a presumption of innocence in his favor, and it stays with him unless and until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or both of the crimes charged. And a defendant should never be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. It doesn't ever shift at some point to the defendant to put up evidence or do anything at all. It does not, however, mean that the state has to prove the defendant's guilt beyond all doubt or to some mathematical certainty. The state's burden is to prove the defendant's guilt beyond a reasonable doubt. And that phrase means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which a reason can be given. And it's a reason that arises from your careful consideration of the evidence or lack of evidence in the case. And the defendant, as I mentioned, bears no burden of proof whatsoever. If, after giving careful consideration to all the evidence that you've seen and heard in the case, you find that your mind is wavering or unsettled or unsatisfied, that is a doubt and is reasonable, and you must acquit the defendant. But if no reasonable doubt exists in your mind, you would be authorized to convict. The basic structure of a trial is that in a few moments, the 2 lawyers, well, there are a bunch of lawyers, 1 lawyer for each side will be given a chance to make what's called an opening statement. This is not evidence. In fact, nothing the lawyers ever say in this case is evidence. It may be an effort to persuade you. It may be a forecast of what the evidence will be, but what lawyers say is advocacy. It is not evidence. Their opening statements are meant to be previews, expectations of what you'll see and hear and learn, or maybe what you won't learn during the course of the trial. Because the defendant has no burden, it may be that his lawyers choose not to give an opening statement. I suspect they will, but if they don't, there's nothing remarkable about that because they don't have an obligation to present anything. Once the opening statements are done, I'll turn to Mr. Whitenauer and ask him to call his first witness. He'll call one of those 4 names that I shared with you yesterday. That person will come up here, sit in that chair. What you see on the camera will change. It'll focus on the witness. And when that witness answers the first question, you will have begun to receive evidence during the trial. The evidence that you receive comes in 2 formats. It is what witnesses say under oath, and it's any physical evidence, a document, a photograph, a hammer, whatever it might be. That's evidence plus witness testimony. Eventually, I'll ask Mr. Whitenauer to call his next witness, and he'll say, "Judge, the state rests." That means they're done presenting their evidence, and I'll turn to the defense and ask Ms. Wood to call her first witness. She may call someone, she may not. No burden on the defense. At some point, when I ask Ms. Wood, call your next witness, she'll say, "We rest." Then we're done with the evidence. You will have seen and heard all of the evidence in the case. That is followed up by closing arguments when the lawyers seek to persuade you to decide the case in their favor. You've heard this evidence, you need to do X or Y or Z, and they will be arguing with you to decide the case in one way or the other. And the last thing that happens before you deliberate is that I provide you the law that you must apply to the facts as you find them to be. So I'll give you the elements of aggravated stalking, the elements of simple battery, and some other legal things you need to consider. And then you will go back into the jury room and begin your deliberations. During the trial, the lawyers have a right to object to the admission of evidence whose admission they believe is contrary to the rules of evidence. You see this on TV all the time. Sometimes the lawyers stand up, sometimes they don't, sometimes they wave their arms around, but either way, they'll say objection, and then it's usually followed by hearsay or speculation, whatever the actual objection is. Sometimes I can rule just based on that because I figured out what was going on. Sometimes I want to hear from the other side, but ultimately I'll say sustained or overruled. If it's sustained, that question needs to stop and the questioner needs to come up with something else. If it's overruled, the questioner can keep on going the direction she was going in. Every once in a while, there'll be an objection and I'll sustain it. And the lawyer who made the objection will say, Judge, I move to strike, which sounds kind of scary. And it doesn't mean anyone's going to get hit. It just means that I may tell you to disregard something that the witness just said. And so if the witness was talking about, well, I was there at the scene and then so-and-so told me, there may be an objection that it's hearsay, and the witness may have said, and that's when the person told me it was raining yesterday. And I'll tell you to disregard what that person just said about the other person saying it was raining. If you wrote that down, you need to cross it out in your notepad. And if you're back there in the jury room and it's deliberation time and someone in your group says, remember that witness who said that other person told them it was raining yesterday, and you remember that's something you were supposed to disregard, I need you collectively to enforce that. The good news is it's not going to be something that's central to the case, because if a witness blurts out something that should not have been said, that is central to the case, instead of there being an objection, you will hear one of the lawyers say, Judge, I have a motion. I'll get very quiet and I'll ask you all to step outside the courtroom and we'll need to work through that. And it may be that that motion is for a mistrial. And if what happened is particularly problematic, it may be that we can't go forward because you cannot unring the bell. The thing that you heard is just not realistic to pretend that you disregard it back there in the jury room. But if I tell you to disregard it, I need you to do that. I need to rule on the motions and on the objections. Nothing that I say in making a ruling should be interpreted by you as some expression of opinion on my part as to whether the defendant is guilty or not guilty, whether one side is doing a better job, whether a witness is credible or not credible. All I'm doing is applying the rules of evidence as I understand them to the situation. If I sustain it, that's all I've done. It means that that was a valid objection. If I overrule it, it means that wasn't the right objection for that situation. You have an important role in this process as well. You are determining the facts of the case. What happened here? And is what the state proved something that they proved beyond a reasonable doubt? Does it rise to that level such that you'd be authorized to find the defendant guilty? And while I'll give you the law that you must apply, you alone will decide what the facts are of this case. And in doing that, you will necessarily be determining the credibility or believability of the witnesses who appear before you. As you're doing that, you are free to consider all of the facts and circumstances of the case, to include the manner of the witness's testimony, the credibility or believability of the witness, the interest or lack of interest that the witness has in the outcome of the case, and the means and opportunity that that witness had for knowing the things she's testifying about. Now, you, much like the lawyers, may have questions about what these witnesses have to say. And it is appropriate for you to express those questions in the following manner. When we're done with each witness's testimony, meaning both sides have had a chance to ask questions, I will ask you all if you have any questions for the witness. And if you do, you'll be jotting them down on those note cards. You'll see on that little shelf in front of the jurors in the center there are a whole bunch of note cards, and you should pass them out to everyone because you may partway through someone's testimony have a question. Write it down so you remember it. But at the end of a witness's testimony, I'll ask Deputy Gordon to collect from you any questions that you may have. They'll look like this. This was my last trial. It was a MARTA bus accident, but jurors had questions. You'll submit them. You don't put your name on the card. You just write the question down. You write on only one side of the card. And then I'll review those questions with the lawyers. Because just like a lawyer question, your question could be objectionable. Not a bad question, it's just not a legally appropriate question. So I have to huddle up with the lawyer so they could say, oh, you know what, Judge, that question calls for hearsay or speculation. You should draw no conclusions or inferences from the fact that a question that you posed was not asked. All it means is that it wasn't a legally proper question. Most of your questions will be spot on. I will ask them of the witness. You don't end up saying anything. You write down your questions. I'll ask the witness whatever questions that were submitted by the jurors are appropriate, and then the lawyers will have a chance to follow up, because what we often learn is that amongst the 14 of you, you have a great angle on something, and the lawyer's like, oh my gosh, I need to follow up on that. So I'll ask the juror questions, and then the lawyers can follow up as they see fit. You may hear some evidence in this case about allegations that Mr. Bryant engaged in conduct outside of what is charged in this indictment. We call them other acts, and there may be some other acts evidence in this case. It's important that you limit your consideration of that evidence for the specific purposes that they've been admitted, which would be the intent of the defendant and the motive of the defendant. And you're not going to have to guess when that happens. Before that witness is called to testify, I'm going to remind you of this again. But that evidence of other acts that Mr. Bryant may have committed outside this April 2021 date is being offered for your consideration to demonstrate, if it does, evidence concerning Mr. Bryant's intent and or motive for the incidents for which he is on trial. Mr. Bryant is not on trial for the other acts about which you may hear from one of the witnesses. It's important that you view the evidence in this case with an open mind, and that you avoid the temptation to reach conclusions until you've heard everything. In fact, it would be kind of peculiar to conclude the defendant is guilty or not until you've heard what the elements of the crime are. You actually don't know specifically what the state has to prove until I charge you at the very end. And there's a reason for the judge, and it's not just me, all judges charge the law at the very end, because if you got it up front, you might say, check, 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 I've heard enough, because the state just proved all those elements. And you wouldn't listen to, for example, if the defense put up a case, which they have no obligation to, but they're free to. So I am requesting that you keep an open mind until you begin your deliberations. It is also important that you decide this case based solely on the evidence presented here in court, which means no outside research. That is why I let you ask questions. If a witness uses a word you don't understand or describes a situation that leaves you confused, the way to scratch that itch is to write down your question on the card. The wrong way to do it is to Google it. If you go home tonight and look something up because you didn't quite understand what was going on, you will be violating my direct order. You may be necessitating a new trial. And the harm that's done is not the innocent, I'm just curious and want my question answered. It's because you are viewing evidence. It's not evidence because it's not here in court. You are gathering information outside the confines where the lawyers could try to rebut it. Because you might go online and look up, if this were this martyr case I had, the young lady whose car got hit by the bus, her ankle was severely injured. These doctors use real complicated terms. If you went on a WebMD to look up a term, you might get an answer, but it might be only part of the answer because of a surgery, the ankle was healed, and you'd be bringing in either partial or misinformation to the rest of the jury for the deliberations. So please, no outside research. If there's a question that you've got, write it down. This also means that when you go home tonight and whoever you live with or whoever you correspond with virtually says, hey, how was your day? What was this trial like? You need to be very circumspect. You can say the judge was phenomenal, but beyond that, you really shouldn't say much, because very well-meaning people will say, oh, let me tell you when I was a juror, or I've never been in a jury, but I know what aggravated stalking is. Let me tell you what that is. And they may be right. That may be the national expert on aggravated stalking, but you know what? She's not a witness here, and neither side gets a chance to ask questions of that person. So be boring when you're talking about what you're doing. When this case is over, if you want to write a book, create a website, do whatever you want, that's fine. It's not confidential once the trial is over, but between now and then, you need to be in enough of a cocoon that you aren't getting information that may be relevant to this case from sources other than the witnesses, the judge, or the lawyers. That's it. That's all I've got. So I'm going to turn now, that's all I've got for now. I'm going to turn now to Mr. Whitenauer to see if he is going to give an opening statement or if Ms. Green is for the state.
I will.
Okay, are you ready?
I am.
Great.
Members of court, defense counsel. Morning. Good afternoon. Stuart Bryant, the defendant, is a bully. And on April 30th of 2021, he was a bully. And I'll tell you why. Because he went there knowing that he wasn't supposed to be there. He went to 3286 Sir Henry Street in East Point, Georgia, which is located in Fulton County. And he knew he wasn't supposed to be there because there was a 12-month temporary protective order prohibiting him from going to, that had awarded sole and exclusive possession to Miss Malika Thomas and prohibited him from coming within 200 yards of Miss Malika Thomas. And guess who was there that day at 3286 Sir Henry Street? Malika Thomas and her 3 minor children, Elizabeth Bryant being one of them. That TPO was in effect from June 19th, 2020 until June 18th, 2021. I'm not the best at calendars, I'm not the best at counting, but April 30th of 2021 falls between those 2 dates. And on that date, he was there at 3286 Sir Henry Street and came within 200 yards of Miss Malika Thomas. And Malika Thomas was there with her minor children, Elizabeth Bryant, Olivia Bryant, and Bryce Bryant, because she was entitled to be there. And she was there for what was supposed to be a fun, an exciting occasion. They were there for a birthday party to celebrate Bryce Bryant's birthday. You'll hear that they had a lot of fun things planned for that day. A video game truck. You might have seen these before. A truck pulls up with a trailer. Inside that trailer, there are flat screens, Xbox, PlayStations, and all the kids go in there and lose their minds playing all the different video games. There was a water slide in the back. They had barbecue, and they had a cooler packed with juice boxes and water bottles. That cooler will be important in a moment. Now, you're going to hear from Malika Thomas. She's the victim in the indictment for the aggravated stalking charge. And you're going to hear from Elizabeth Bryant, the daughter, who's the victim in the battery family violence charge. That's the second one. It's a misdemeanor. The first is a felony, the second is a misdemeanor. We're going to call Elizabeth Bryant to the stand first. She'll sit right here, and she'll raise her right hand. She'll be put under oath, and she's going to testify about what happened that day. She'll tell you, I was there for the birthday party. It was going to be a fun day. And it was until Mr. Bryant showed up and showed out. He came there on a mission to continue his pattern of intimidation and harassment of Malika Thomas. So you'll hear her testify that first, that she was in the kitchen when the defendant arrived, that he walked straight in, ran upstairs, and tell everyone to get the fuck out. Right? Because that's what you do at a kid's birthday party. And everyone obviously knew he was there. Ms. Bryant knew he was there. And so then, after running upstairs, he comes back downstairs and sees that cooler. And that upsets him because that's his cooler. And so what do you do in that situation? You knock it over. he knocked over the cooler that's there, the juice boxes and the water bottles for the kids for the birthday party. And at that point, he starts to call everyone words, calling Miss Bryant bitch and stupid, and saying, y'all going to jail, threats. And it was at this point, while Miss Bryant is trying to save whatever could be saved of that birthday party, is trying to pick up some of those juice boxes and water bottles. It was at this point that Mr. Bryant decided to grab Mr. Bryant, his dog, and slam her to the ground. And she'll testify that she struck her head on the hardwood floor, and guess what? It hurt. And she'll testify that during this assault of her by Mr. Bryant, that he was calling her names like ghetto. Apparently, he was offended by the weave that she had, or the dreads that she had, and the fake nails that she had on her fingers. And those nails offended him so much that you'll hear her testify that he grabbed those nails and ripped it off. And she'll tell you that hurt. And that is the basis for the insulting and provoking nature of his assault against her that day. That is the basis for that battery family violence. A father assaulting his daughter at a birthday party. But it won't just be for testimony. They'll be provided with 3 photos of her from that day, a photo from afar, a photo close up on her hand, and then a photo of that fingernail. And you'll say, well, it's just a fake fingernail. Well, that fake fingernail was attached to her body, and he ripped it off. And for those of you who've had fake fingernails, I would imagine that would hurt, ripping it off and breaking that glue contact. You'll also hear the 911 calls from Miss Bryant. She made several, desperate to get the police there, to intervene, to remove this man from that house, to remove this chaos that he had introduced. They did ultimately come, and you'll hear from those police officers. Next, you'll hear from Miss Malika Thomas. And again, she is the victim in the aggravated stalking count 1. And she's going to tell you somewhat some of the same things that Miss Bryant tells you that were there for a birthday party. That they had ordered a lot of entertainment for the kids that day. And that fun and that entertainment came to a screeching halt when Mr. Bryant stormed in. She'll tell you that she knew that he had arrived because the children were screaming, "Mom, Stuart's in the house." That he walked upstairs, that he went to the master bedroom, he peeked in there, and then went to the son's room, Bryce's room, the kid who was having a birthday party that day, and heard him say, "Oh, you took my Xbox." And then he came downstairs, and then there was that cooler. And he said it was his, and he dumped it over. He said, "It's my cooler, you can't use it." And then started to tell Miss Thomas to get the fuck out of my house. While that happened, Miss Thomas was there, family members there, minor children were there. And she said, "Oh, the cops." That's what she did. She called the cops, and you'll get to hear that 911 call. You're also going to get to hear about some prior difficulties that Mr. Bryant has inflicted upon Ms. Thomas as part of that pattern of intimidation and harassment against her. So here they were married in about 2004, that they've been married and are in the process of a divorce for about 18 years. And that marriage produced those 3 minor children. And you'll hear that on 3 instances, which serves as the basis for that pattern of harassment and intimidation, 3 instances in which Mr. Bryant continued his assaultive behavior, his controlling behavior of Ms. Thomas. You'll hear about an incident in 2015 when Ms. Thomas and Mr. Bryant were having an argument outside of their house. And out of nowhere, Mr. Bryant pushed her into the bushes and kicked her about the head. And that this assault injured her ankle such that for the next few days, she was hobbling around at work. You'll hear about an incident in February of 2020. So just a little bit more than a year before this April 30th, 2021 incident, that Ms. Thomas was in her bedroom, minding her own business. She had locked her door and was on the phone. That the defendant busted in through that door, took her phone, called her a whore, and then slapped her. Ms. Thomas will testify to that, and Ms. Bryant can also testify to that. And you'll hear about the third incident, another part of that pattern of intimidation and harassment by Mr. Bryant against Ms. Thomas. In March of 2020, so just 1 month later, that Ms. Thomas was preparing to go to work. She just wanted to leave the house and work. And she was braiding her hair. Now, she was trying to leave the house. Mr. Bryant attempted to physically restrain her, grabbing her, such that by the time that she got to the driveway and was trying to back up, he was still trying to block her in the door. And so, April 30th, 2021 was not an isolated incident. It was part of Mr. Bryant's bullying pattern of behavior to intimidate and harass Ms. Thomas. And you can infer from the fact that he arrived there that day with that TPO, knowing that it was in effect, and knowing that Ms. Thomas would be there, that he intended to continue that pattern of intimidation and harassment. You'll then hear from 2 officers, Officer Clervo and then Sergeant Broussard. Now, these are officers with the East Point Police Department. They arrived on scene. Officer Clervo will tell you that he arrived dispatched to that location on Henry Street in response to a fight. And indeed, there had been a fight, though I would describe it as an assault by Mr. Bryant against Ms. Bryant. Spoke with Ms. Thomas. She'll tell you that there was a TPO in effect and that the defendant had arrived about 6 p.m. and that she requested that he leave and provided the officer with a copy of that TPO. You will get to see that TPO. You will get to look at it. You will see the date that it was signed, the dates that prohibited him from having contact with her. You'll get to review that. And he'll tell you that it was reported to her that Mr. Bryant turned over the cooler, called her, Ms. Thomas, and the daughters bitches. He became verbally aggressive, and that he refused to leave. Officer Clervo is going to tell you that he also spoke with Elizabeth Bryant, and that she insisted, what I think she's going to testify to today, that he, Mr. Bryant, pushed her to the ground and caused her nails to break. Sergeant Broussard arrived on the scene, and Officer Clervo took that TPO that he had received from Ms. Thomas and gave it to Sergeant Broussard. And he went to his patrol car where he has a terminal that's lawfully connected to GCIC, which is a criminal database for Georgia. And in checking GCIC, he was able to determine that Mr. Bryant had been served with a TPO and that it was in fact active. And of course it was. It was April 30th, 2021, which falls between those dates of June 2020 and June 2021. And having done that and having confirmed that Mr. Bryant was within 200 yards of Ms. Thomas, placed him under arrest for aggravated stalking, and here we are today. And our office has indicted him, the grand jury has indicted him for aggravated stalking, felony, and battery, family violence. Now, you can see body cam from these officers. They have a little camera on their chest. You can see body cam from Officer Clervo and then body cam from Sergeant Broussard. You'll get to hear what the defendant says while he's being escorted to that patrol vehicle. You'll hear him indicate knowledge of the 12-month TPO and claim that it expired, or claim that he believed it expired. Of course, it hadn't. You'll have it in front of you. You'll see that it hadn't, and he was there in violation of it. It was valid from June 19, 2020 to June 18, 2021, and on April 30th, 2021, Mr. Bryant, the bully, went there, was within 200 yards of Ms. Thomas, to intimidate and harass her as part of that pattern, and to batter his own daughter. And for his behavior that day, and for his violation of the law, I ask that he hold him responsible, I ask that he render a just verdict, I ask that he render a verdict of guilty.
Thank you, Mr. Whitenauer. Ms. Wood, are you given an opening now or are you reserving or no opening?
Opening now, Judge.
All right, when you're ready.
Things are not always as they seem. You ever heard that saying? means the situation might appear to be one way, but in reality, it's entirely different. I want to tell you all a story about the date of April 30th, 2020. Mr. Whitehouse will do a little bit. I want to fill in our version, our side of the story. On April 30th, 2021, my client Stuart was headed to 3286 Serving Street. He was headed there for the purpose of determining if the house was vacant, and we'll get into that later. If there had been any damage done to the property, there was lawfully is. And to see if anything had changed with that property in the nearly 14 months since he had been away from it. So as Stuart running onto the street, onto Sir Henry Street, car rolls to a stop. He gets out of the car and he observes his home on its slope. And he realizes that it's not vacant at all. In fact, there's a party going on, a party he was not invited to. Now I'm willing to bet Stuart might tell you, hindsight is 20/20. But looking back, he might have made a different choice. But he didn't that day, and that's why we're here. So he gets out of the car and he starts walking up the grassy slope. Once he gets there, he's met by Malika Thomas, Elizabeth Bryant, Malika's mother. Now, the state and I have different interpretations of what happens next. I'm going to tell you, my perspective is that it was chaos. There was yelling, there was cussing, it was pandemonium. Stuart called 911, Malika called 911, Elizabeth called 911, Malika's mom called 911. As they're waiting for the officers to arrive, still Stuart is here, Malika is here, Malika and Elizabeth have not walked away, they've not disengaged, they've not done any of that. Officers arrive, they take Stuart over here, they take Malika over here. Malika's given the chance to show the officer her paperwork. While Stuart's over here, because he doesn't have the paperwork freely in his hand because he's not at his home. Well, it is his home, but he hasn't been able to live there for the past 14 months. So he's only able to verbally tell the officer, I'm able to be here. The TPO against me expired March 2021. I have my own TPO against Malika, dated April 15, 2021, which was supposed to have her vacate 3286 Sir Henry Street. He's honest, he's open. He's telling the officers that is the only reason I'm here. I've had no issue staying away and not contacting Malika the past nearly 14 months since he was properly served in March 2020. And instead of that officer giving him the opportunity to phone a friend or have his mom bring the paperwork, they slapped the cuffs on him. They slapped those cuffs on him, and here he sits, charged with a felony. A man with no felony convictions, a good job as an electrician, his life is turned upside down because of this case. Things are not as they always seem. Now, if you'll allow me, I want to take a step back and paint a little broader picture for you. I want to take you back to 2004. Stuart in 2004 was a younger man, and he and Malika Thomas had a relationship. A baby, a pregnancy. comes to life. His mother encouraged him to do the right thing in her mind and get married to Miss Thomas. So in 2004, they're young, they're newlyweds, they have a new baby. They have, right off the jump, they have a very interesting family dynamic. But still, they're trying to make it work. They're a family of 3. They're working, they're living life, they're raising their baby. And then 2 years later, they're still married and they have another baby. And still, they keep on. Now they're a family of 4 and they're working, living life, raising their baby. 3 years later, 2009, the 3rd baby comes into the picture. So now they're a party of 5. Having 1 child added to the relationship dynamic changes things. Adding 3 completely changes the dynamic. Stuart and Malika, it's clear, did not have a healthy relationship to begin with. And when the stresses of having 3 children added in to trying to, have a house and make a living, it exacerbates problems that were already there. Stuart and Malika decided after the 3rd child was born, somewhere around approximately 2010, that, hey, we want to try to make this work for our 3 kids, but we cannot continue as a couple. We've got this nice house at 3286 Sir Henry Street, so let's separate while still being together. We'll just, work out the children's stuff together, but everything else we're separate. He had a different bedroom. The master bedroom was his area. And so they continued in this dynamic for about 10 years. It wasn't easy. Clearly, it wasn't the best idea. And as we all know, relationships don't always work out. Some marriages simply just aren't meant to last. So now I want to fast forward to March 2020. You may remember what happened in March 2020. A global pandemic came in and disrupted everybody's lives. People lost jobs, people got sick, people died, people lost loved ones. That's not the only thing that was disrupted in March 2020. In early March 2020, Malika Thomas did 2 things. She filed for divorce, and she took out a temporary protective order against Stuart. He was served at 3286 Sir Henry Street and forced to leave and move in with his mother, a grown man with a good paying job and a family, forced to go back to mom's house. But he went without fight, without arguing, without kicking and crying, none of that. He went. So from March 2020 all the way up to April 2021, he has not bothered Malika Thomas. He has not went over there to that house. He has minded his business and kept away. Now, please note that I mentioned he was properly served in March 2020 with that TPO. Stuart was never served with the updated orders because the service was done at 3286 Sir Henry Street, where he was told not to be. Therefore, he never got it. But we'll talk about that more as the trial proceeds. So on April 15th, 2021, Stuart goes and gets his own temporary protective order. Like I said, there's allegations on both sides. It's clear it's an unhealthy arrangement for both of them. So he gets his order on April 15th, 2021. And he waits 2 weeks. Waits 2 weeks until he goes over to 3286 Sir Henry Street to see if the property's been vacated, see if there's any property damage. Why, you ask? He is ready to pick up the pieces from this tumultuous relationship, try to move forward, try to start healing. And the first step in his mind was to figure out what to do with their narrow property. This house that had both of their names on it, something needed to happen with that. So on April 30th, a fateful day, he goes over, thinking in his mind, TPO against me expired March 2021, because that's the only one he's been served properly. And in his mind, he's under the impression that his TPO from April 15th is good to go. Ladies and gentlemen, I present to you, there is no proof of him going to that house on April 30th, 2021 to intimidate, harm, or harass Malika Thomas or anyone else at that home. And that is what we're asking you to do today. That's what is in the indictment. I'm asking you all to deliver the only true verdict in this case, and that's not guilty. Thank you.
Thank you, Ms. Wood. Mr. Whitenauer, call your first witness, please.
Yes, Judge, 88 Green will be handling our first witness.
Great. Ms. Green, the first witness is?
Elizabeth Bryant, Judge.
We swear affirm that testimony you will give is the truth, the whole truth, and nothing but the truth, so help you. Yeah, I see. Hey, let's spell your name for the record.
You said the same.
Say your name.
Elizabeth Bryant.
There's a box right there. Ms. Bryant, I'm Judge McBurney. It's nice to meet you. Do you mind removing your mask for your testimony? Thank you. It'll make it easier to hear you. And that microphone bends a little bit. If you could bend it closer to you. And then the chair you're in, it doesn't have wheels, unfortunately, but that's good because you won't roll off the stand. Can you slide forward a little bit so you're closer to the microphone? That way everyone will be able to hear you. Great. And you can bend the top of the microphone down a little bit. Excellent. Okay. Thank you so much. Ms. Green, when you are ready.
Yes, Judge. Good morning, Ms. Bryant.
Good morning.
Are you nervous?
Yes.
I know. So we spoke earlier. We're just gonna go through that again, okay? All right, and you let me know if you need anything. Okay.
And Ms. Bryant, when you're answering questions, I know you may want to just nod your head or shake your head. I need to make sure so the court reporter who's sitting right in front of me can take down your answers. You're welcome to nod or shake, but you also need to add to it a yes or a no, or I'm not sure, whatever your answer is.
Okay.
Make sure it comes out loud, okay?
All right.
Thank you.
All right. So once again, can you say your name for the record?
Elizabeth Bryant.
Elizabeth Bryant. How old are you, Ms. Bryant?
I'm 18.
And what school do you go to?
At Tennessee State.
Okay. Any extracurricular activities?
I'm marching the band there.
Okay. Who is your mother?
Malika Thomas.
Okay. And who is your father?
Stuart Bryant.
Okay. And do you have any brothers or sisters?
Yes, I have a brother and a sister.
And who is your brother?
Bryce Bryant.
Okay. And your sister?
Olivia Bryant.
Okay. Have you had an opportunity to review the indictment in this case?
Yes.
Okay. And have you had the opportunity to review count 2 in the indictment?
Yes, ma'am.
Is that your correct name as it's listed in count two?
No, it's not.
Okay. And like you said, your name is Elizabeth
Elizabeth Bryant.
Are you the person referenced in count two of the indictment?
Yes, I am.
Okay. All right. So do you recall the incident that occurred on April 30th, 2021?
Yes, I do.
Okay. Where were you?
I was at home, 3286 Henry Street.
All right. Just speak up for me a little bit, okay?
Okay.
You said you were at home?
Yes.
Okay, and what was the address?
3286 Sir Henry Street.
Great, that was much better. Thank you.
All right.
And what county is that in?
East Point, Fulton County.
Thank you. And who were you with?
I was with my family, my mother's side of the family.
Okay. Like who?
Like my mom, my little cousins, my sister, my brother, my grandma.
Were you doing anything specific that you remember that day?
We were celebrating my brother's birthday.
Bryce.
Yes.
Okay. And how do you recall how old he was turning that day?
12.
12. Okay. What's your date of birth?
August 31st, 2004.
Okay. So how old were you at that time?
I was 16.
Okay. What do you recall happening that day?
So as I said, we were celebrating my brother's birthday. All my cousins, we were all in the house. They were outside in the backyard because we had a bouncy house in the backyard. And in the front yard, we had a game truck. So we were just celebrating his birthday. And that's when Stuart, my father, he walked in.
Okay.
He was very angry. He was telling everybody to, get the
You can
Can I
say
cut-
what he said if you feel comfortable.
okay, he was telling everybody to get the fuck out his house. He went upstairs, and by that time I was in the living room. And then he came down the stairs, and he proceeded to call us out our names. Me and my mom. He was telling us to get out.
What did he call you?
He called me ghetto. He called me bitches, whores, things like that.
Okay. Was there any interactions that you had with him?
Yes.
And tell us about that.
So for the birthday party, we had a cooler that had all the drinks in it and stuff. And he was like, that's my cooler. So he went over and he began taking the drinks out, emptying the cooler because he said it was his. So and while he was doing that, he was calling us stupid and stuff. So I bent over in the cooler and I was just telling him to leave, and I was putting the stuff back in there because it's my brother's birthday. So I was just putting the stuff back in there. As he's taking the stuff out, he got frustrated because I was he was trying to take stuff out. I was putting it in. He got frustrated and he grabbed me by my shoulders and he kind of pushed me to the side.
Okay.
And
what happened when he did that?
Hit my head on the ground.
Okay.
And
what did that feel like?
it hurt.
Okay.
Mm-hmm.
You can continue. What else happened?
I get up and I'm on the phone with the police at that point. And I'm just asking him to leave, we're telling him to get out, and he's just walking around, tormenting, calling my mom stuff. And in the cooler, he saw I had nails on, and he was talking about my hair. He was saying that it was ghetto that I had weave in my hair, and I had on nail extensions. You call it. Yeah. He saw I had that on, and he was like, "This is ghetto." He just ripped the nail off my thumb.
Okay.
In the while we were taking stuff out the cooler.
And do you recall when you got your nails done?
It was probably 2 days before that. They were fairly new.
Okay. And what, if anything, does that matter? If that they were fairly new?
When they're when you first get your nails done, like the adhesive is like very strong. So for you to pull it off, it really hurts.
And did it hurt?
Yeah, it hurt really bad.
Okay. And you stated that you called 911, correct?
Yes, I did.
Judge, may I approach the witness?
You may, if you've got a set of exhibits, let's leave the set with her. That'd be great.
Yes, Judge.
Thanks.
What did I just show you?
Pictures of me from the day.
Okay, and how many pictures?
3 and a CD.
Okay, and what, how do you recognize the CD? Let's start with the CD.
You said, how do I recognize it?
Mhm.
It's the 911 call. Right?
Have you had an opportunity to listen to the 911 calls?
Yes, ma'am.
And how do you know that's the disc that you listened to?
I signed it, listened to it today.
Okay. And when you listened to those 911 calls, were they fair and accurate of the calls that you made on that day?
Yes, ma'am.
Were there any alterations or deletions made to those calls?
Oh, ma'am.
Okay. And so at this time, the state moves to enter in State's Exhibit 1, which is the 911 calls?
Any objection? It's the disc with the 911 calls on it.
Yes, Judge.
Any objection to states 1?
Judge, I just want to confirm, there are a couple that are not coming in. I just want to make sure they're not on that CD.
Okay, meaning there are multiple calls, some of which people have agreed ought to come in trial and some not?
Yes, Judge.
Yes, Judge. There are 4 calls total, and we will only be publishing 3 of them.
Okay, well, we just need to make sure if there's a 4th on there that, because the disc, if it's admitted, which it sounds like it will be, will go back with the jurors. They won't have a way to play it during their deliberations, but if they want to listen to the calls again during their deliberations, they can do that. We'll just need to make sure that, I'm gonna call it call 4, doesn't get played, because that's not something that is being made. This will all be made part of the record, but part of the record the jurors can consider. Does that make sense?
Yes.
Are you all right with that, Ms. Wood, if we manage it that way?
Yes, Judge.
Okay, then I'll admit states 1 with the caveat that one of the 4 calls to be identified later won't be published and won't be playable during deliberations.
All right. And so at this time, Judge, the state moves to publish the first call.
Okay,
Yep. So this is going to be.
so a reminder, when you're doing the share screen, there's a little box that says share audio as well. Just make sure you click that. It'll sound better for everyone.
Yes, Judge. So I'm gonna play 34434 first.
All right, and so the first call that is published now is identified by number 34434.
Hello?
Hello, someone dialed 911.
Yes, can you come here? So basically my father, he's really abusive. He just broke the restraining order against my mom and he's at my house. Can you please come?
What's your address, ma'am?
3286 on Henry Street.
Sir Henry?
Yes, ma'am, if you please hurry.
Black male?
Yes, he's black, Stewart.
Okay, what's his
Yes,
name?
dreads.
Okay. What kind of clothing?
He has on a black shirt that says 420. Can you please hurry?
All right, we'll get someone out. What's your name?
Elizabeth Bryant.
Okay, we'll get someone out.
Right. So can you stay on the phone or something? I don't know what to do.
Okay, I'll stay on the phone with you, ma'am, until police get there.
Get out! What is wrong with you, dumbass? I don't care what it is. Get out of it, dumbass! Get out! Get out! Nobody wants you around. Get out! That's fine.
286.
Get the fuck out.
Sir Henry Street.
Get out!
And not 40, right? All right, next.
Okay, and now we're gonna play the second call. That call is identified as call number 34436.
The address of your emergency. This is 3286 Henry. Can you please hurry up? They're en route to you, ma'am. What's going on now? He hit me. I can't deal with this. Okay, they're en route to you. What is he wearing? Yeah, we have a restraining order on him. I have the documentation. Can you please come and get him? He just left. Okay. Mom, he left. Was he in a vehicle? Yes.
What kind of car?
I think it was a Honda Pilot, white. That's his car. He doesn't have a license to be driving, so I don't know how he get over here.
Okay. All right. They'll be there shortly, okay? They're en route to you. They're coming. All right?
Please hurry up.
Okay. They'll be there shortly.
I'm sorry.
They'll be there shortly, ma'am. Okay?
Yes, can you stay on the phone?
All right.
Thank you.
Right there, you continue to ask, please stay on the phone. Why?
I was scared.
Okay.
It's the end of that clip.
Okay. And then the third call, Your Honor, that will be identified as 34437.
You're so crazy. That's so sad. Birthday party ruined. Yeah, it is.
Right there. What did you say?
I said, this is so sad. My brother's birthday party's ruined.
Had the party stopped at this point?
I mean, everybody was trying to get situated, but I mean, yeah, he disturbed the party.
Okay.
Goodbye. Goodbye.
Still there?
It's Tiffany, but okay. Can you please hurry? He's getting violent. He just slapped me.
He came back.
You said he's getting violent. He just slapped me. What happened?
My phone. Yeah.
Help explain a little bit better. You were on the phone?
I was on the phone with the police.
Mm-hmm.
And he came back inside because he left. He came back inside. I'm on the phone with the police. Comes up to me, slaps the phone out of my hand.
Okay.
I'll let you record everything.
Ma'am.
He's recording it.
Ma'am, did he come back?
Please hurry up. Please hurry up.
Ma'am.
He's hitting me.
Did he come back?
Please. Please, please, please. Please hurry up. I don't care what you're doing. Okay. Whatever.
Ma'am.
That's funny.
Ma'am.
Yes.
Did he come back?
He's in the house right now.
Okay. All right, they're coming. Hold on 1 second. Hold on.
And for the record, the state will not be publishing calls identified as 34440, which is the fourth call.
Okay, and that one, 34440, is the one that not only is not being published, but by agreement wouldn't be played at any point during the trial unless there's a new agreement. Is that fair?
Yes, Judge.
Okay. All right.
Right. Now we're going to move on to when the officers arrived. Do you recall?
Yes, ma'am.
Okay.
I need you to speak up, Ms. Bryant.
Sorry. Yes, I recall.
Okay. Do you recall speaking with the officers?
I do.
Okay. And did you take any photos when the officers arrived?
I did.
Okay.
Of my nails.
Yeah. And so I asked you earlier, what was I showing you? And you identified that was being pictures of yourself. How have you identified those pictures in any way by making any markings on them?
Oh, yes, I did.
Okay.
I signed the back of them.
Okay. And is that a fair and accurate depiction of how you looked on that day?
Yes, it is.
Has there been any alterations or deletions to those photos?
No.
Okay. The state now moves to enter in states exhibit 2 through 4.
Any objection to states 2 through 4?
No, Your Honor.
They're admitted.
State moves to publish exhibit 2. Is that you that day?
Yes, it is.
Okay. And how would you describe your?
One second. You needed to be able to see that. All right. So
I stopped screen sharing, judges, in case it was something.
no, it's fine.
behind.
Ms. Bryant was simply trying to see the monitor, and there were a couple of things blocking it. If you'll hit got it, then we should be okay. All right, we're good.
Thank you. In this photo, where was I? How would you describe your hair?
I had passion twist.
Okay.
What's the term?
Passion twist.
Passion twists?
Yes.
Okay.
And are those are your nails on the day of the incident? How would you describe your nails?
I had nail extensions, yeah.
Okay. And then publishing exhibit 3. And what are we seeing in this photo?
Those are my nails, and you can see the broken nail.
Okay. And then publishing exhibit 4.
It's a broken nail.
Is that the nail that he ripped off of your hand?
Yes, ma'am.
Okay. All right. Do you see the person that did that to you that day in this courtroom?
Yes.
Who point him out and describe a piece of clothing?
So you don't actually need to point if you're not comfortable doing that, but I do need you to describe an article of clothing and where the person is sitting. So I understand the person you're describing.
He's sitting over there.
Okay.
I would like the record to reflect that that the witness identified Stuart Bryant.
You need a break, Ms. Bryant, or are you okay?
I'm okay.
Okay. All right.
Miss Bryant, why are you crying right now?
So it's a lot. In the same room.
I'm sorry. I'll wait. Let's wait. I'll give you a minute.
I'm okay.
Your Honor, may we recess?
Just one.
Sure. Why don't we do that? And it might help, Ms. Green, if you stood over at the corner of your desk for the rest of your questions. Okay, great. All right. We're going to take a quick break, ladies and gentlemen. We'll bring you back out here in a couple minutes. You all should go to the jury room. Remember, don't talk about the case yet. Talk about anything else you want. Bring your notepads with you, and we'll bring you back out in a second.
We got any of that ID. We've got all the elements of supporting integration.
All right, Ms. Bryant, why don't you can step down for a minute. You can go out in the hallway and when you think you're comfortable going forward, just let us know, okay? Thank you. I need one of the prosecutors to stay here.
I'm here.
Okay. Mr. Whitenauer, anything before we go on break?
No, Judge.
Okay, Ms. Wood, anything before we go on break? All right, great. Stay nearby. I would like to get I don't think this should be our afternoon break yet. So as soon as Ms. Bryant is ready to go, let's keep going. We'll take our afternoon break closer to 3 than right now. So I'm not going anywhere. We can go off the record now.
Yes, Judge. Yeah, this is the surgery. On the what? Oh, thank you. It's not. It's not it. It's the wrong. I don't know if we got that. I'm just saying. Okay. It's coming with page. Oh, okay. I got it.
All right, Ms. Rivers, are you ready? Okay. Ms. Bryant, you okay if we bring the jurors back in?
Yes.
All right, Ms. Green, how much more time do you think your examination is going to go? Okay. Ms. Bryant, if you need to take a break again, let us know, all right?
Okay.
Okay, great. Ms. Wood, anything before we bring the jurors in?
No.
All right, let's bring them in, please. They didn't flee to the restroom.
All right, adjourned. Here's the president.
Thank you, Deputy Gordon. Couple things, jurors, and you all can be seated. One, you'll get a longer, uh-oh. You will get a slightly longer break when we have our afternoon break. Second, I forgot to mention, there's a fridge in the jury room. It has bottled water in it. That's for you, and you're welcome to bring this out here. If you bring a brown beverage, do not spill your brown beverage. I hope that didn't spill, the thing you just dropped on the ground. Good, okay. Perfect example of what not to do, though. Bring your bottled water, you can spill that. That's all right. The brown beverage out here needs to not spill. And if you run out of bottled water, let us know. We can get more. You're welcome to bring things in to put in the refrigerator, to use the microwave. And there is a K-Cup type machine back there. That's for you to use as well. And if there are any K-Cup things back there, use them also, but don't bring the brown beverage out here and drop it. All right. With that, we're going to continue with the direct examination of Ms. Bryant.
Brian, how are you crying?
Having to look at him, it's just
Maybe a little bit.
having to look at him, it did a lot to me.
After recalling everything that happened that day, how did that make you feel? Started.
It's just really bad. I don't. It just didn't. It felt bad.
No further questions, please.
All right. Ms. Wood, do you have any questions for Ms. Bryant?
Just a couple, Judge.
Okay.
Hi, Ms. Bryant.
Hello.
You answered one of Miss Green's questions that it was a birthday party and there were a number of people at the house.
Yes.
Were there other adults there?
My older cousins, my mom, my grandma. Those majority kids.
And the kids were, I don't remember how old your brother was turning at the time.
He was turning 12, so my younger cousins, they're like 8, 7, just little children.
So it was littler kids.
Yes.
Okay.
And you called 911, correct?
Yes.
Did you call right when he arrived at the house?
Right when I saw him, I called the cops.
And that was you on the 911 call saying dumbass, correct?
Yes.
And it was you saying get the fuck out, correct?
Yes.
You indicated that your nail was broken, but your
Yes.
actual nail was not broken, correct?
Correct.
It was the acrylic.
Yes.
So your actual physical nail that's attached to your body was not ripped off, correct?
I don't think so. I mean, it still hurt the same.
One moment, Judge.
You okay? Okay.
No further questions, Judge. Thank you, Ms. Bryant.
Any redirect?
No, Judge.
Any questions from the jurors? All right. Ms. Bryant, thank you for being here. You are free to go.
Thank you.
All right. You can leave that stuff right there. The lawyers will take care of that. Appreciate it. Ms. Green, next witness?
Yes, Judge.
You're flying solo, or Mr. Hand is stepping in.
No, the next witness, hold on one second, it'll be White and Howard's witness, if you give me a second.
Okay. A logistical question. Yeah, so I'm sorry, what I meant when I said, do the jurors have any questions? If you had questions you wanted to ask the witness, you would have jotted them down, or I'd give you time to jot them down. And then once you've jotted them down, so you can jot them down as they come to your head, or at the end, when I turn to you all and say, do you have any questions? You can say, yep, and you write them down then. Then Deputy Gordon will collect them and we'll go through that routine. Okay? So for future reference, because Ms. Bryant, it's now done. All right. Next witness, Mr. Whitenauer.
Yes, Judge, we call Malika Thomas. She's on her way in.
Great.
Just take that to testify.
We got to see, can you read right now? You are going to testimony to reveal the truth, the whole truth, and nothing but the truth so help you. Go ahead and have a seat. Statement, spell your name, please.
My name is Malika Thomas. Malika Thomas.
Ms. Thomas, I'm Judge McBurney. It's nice to meet you. Appreciate you being here. If you're comfortable, it would help us if you removed your mask because we'll be able to hear you a lot better. You're going to be answering questions for a little bit. And the closer you can get to the microphone, the better we'll be able to hear you as you're answering the questions. And if you need to take a break at any time, please let me know. All right?
Okay,
Thank you. Mr. Whitenauer, when you're ready.
Thank you, Judge. Good afternoon, Ms. Thomas. How are you?
I'm okay.
All right. So like your daughter, you're a little bit soft spoken. So I think you just try to remember to lean into that microphone and raise your voice up a little bit.
Yes,
You tell the jury your answers.
yes.
Ms. Thomas, where do you live?
East Point, 3286 Sir Henry Street, East Point, Georgia.
You know what county that is in?
That's Fulton County.
Do you know Stuart Bryant?
Yes.
How do you know him?
Married to him.
Do you see him in the courtroom today?
Yes.
Can you identify him by describing an article of clothing he's wearing?
Looks like maybe a blue shirt.
I mean, that's correct, but then
I can't
I
quite
see the
see.
witness has identified the defendant's face.
She has.
How do you know Mr. Bryant?
We were married, are still currently married for 18 years, separated for 3.
Do you remember when you married Mr. Bryant?
August of 2004.
And do you have any children with Mr. Bryant?
Yes, I have 3 children with him.
What are their names?
Elizabeth Bryant, Olivia Bryant, and Bryce Bryant.
How old are your children today?
They are 18, 16, and 13.
Now, you say you're still married to Mr. Bryant. Are there any proceedings regarding your marriage?
Yes, we are going through a divorce at this moment. Yes.
When did you file for divorce?
The first time I filed for divorce was, what year is this? 2022. I want to say maybe 2018 or 19 was the first time that I think I filed.
Did you file for divorce another time?
A time after that, the divorce was dismissed, and I refiled, and then, yeah.
When you refiled,
Um,
approximately?
yes, 2020, I do believe. I think that was maybe April or May.
You have 3 children, right?
Yes,
You have birthday parties for your children?
absolutely.
And did you have an occasion in April of 2020 to have a birthday party for one of your children?
Yes, my son,
Your son again?
Bryce. Yes,
You recall how old he was turning?
yes, Bryce was turning 12.
Okay.
11.
And where was that party to occur?
It was at our home in East Point. Yes.
And just, can you describe to the jury that home? 1 story, 2 stories, front yard, backyard?
2 stories, backyard, front yard. Yes, we had a little game truck in the front and water slide in the back, barbecue, music, a bunch of kids, family and friends.
For those who might not be familiar, can you tell the jury what is a game truck?
Oh, it's a truck and it has just video games for the kids to get in and play video games. I think this one may have fit maybe 15 to 20 kids and they could just play different, video games of their liking.
Or the dad, if the dad gets it for the kid's birthday party, the dad can go in there as well.
That's right.
Just full disclosure, parents have been in there too.
All right, so kids and grown men go in that truck and
Yeah.
play video games
For hours.
for hours.
Yes.
All right.
Mhm.
Was there any entertainment in the backyard?
Yes, water slide, barbecue.
All right.
Yes.
And were there any drinks for the guests?
Yeah, we had a cooler sitting there with just ice, little bottles of waters, juice boxes. I didn't buy any sodas, so just juice boxes and waters.
Who all was invited to that party?
Family and friends. Yeah, just family, friends, my son, some of his friends, family members.
Were you there that day?
Absolutely.
Were your children there that day?
Yes, they were.
Was your mom there that day?
Yes, she was.
Were any cousins there?
Yeah.
And were there friends of Bryce there?
Yes.
Do you know about how many people were in attendance for that party that day?
There were probably about 25 kids, maybe 7 or 8 adults.
And do you remember about what time that party began on April 30th, 2020?
I think we started at about 5.
And
Yeah,
how was the party?
it was good.
All right. Was Bryce having fun?
Yeah, he had a great time. He still talks about it.
Great. At a certain point, did that fun disappear?
Absolutely.
When did that fun disappear?
Maybe about an hour into the party. We had the doors unlocked because we were, the kids and people were, coming in and out of the house. Mr. Bryant walked into the house and my kids started screaming, "Mom, Dad's here," came out, peeked out. He was standing at the top of the stairs, upstairs,
And where were you at that time?
downstairs.
And were you able to see him from where you were standing?
Yes.
How would you describe his demeanor when you first saw him?
Angry, aggressive,
How would you describe his tone?
loud, aggressive, rude.
And were you able to see where he went when he went upstairs?
The first thing he did was, from what I saw, was peek into the bedroom that he used to sleep in. Then he went to my son's room and made a comment about an Xbox.
Remember what that comment was?
Yeah, he said to my son, "So I see you took my Xbox out of my room." Didn't tell the kid happy birthday or anything.
Were those the first words to your son?
Yes.
That was to Bryce?
Yes, to Bryce.
On his birthday?
On his birthday.
At his birthday party?
At his birthday party, yes.
What did he do after making that comment to Bryce?
I think he came down the stairs.
All right. And where did he go downstairs?
He came downstairs. We were standing like sort of in front of the cooler. He proceeded to like, this is my cooler. Y'all can't use it. Pick the cooler up, dumps it out, with the little juice boxes and little waters in it, and proceeded to scream at everybody, tell them to get the fuck out of his house. And he looked over at me and said, "You fat bitch, you're going to jail." because you're destroying my house or whatever. Yeah,
Have you destroyed his house that day?
no.
Was it his house?
I mean, it's in his name, the mortgage is. He used to live there, yes.
How close was he when he called you a bad bitch?
In my face,
How close?
in my face.
So you've raised your hand, and so there's a record. Can you describe about how close he was?
He was almost nose to nose. Yeah,
All right.
yeah.
And when he said that, what was his demeanor? What was his tone?
Very aggressive, very loud, very threatening, just normal, his typical behavior.
And was Mr. Bryant invited to that birthday party that day?
No,
Had you invited him?
absolutely not.
Are you aware of anyone else having invited him?
No,
Did you want him to be there, or maybe you forgot to invite him?
no.
And why did you not want him there that day?
We have a protective order. We had a protective order against Mr. Bryant.
I'm showing now what's been pre-marked as States Exhibit 5 and 6 to Defense Counsel. Your Honor, may I approach the witness?
You may. Are those all the exhibits you're going to use with the witness?
They are.
Great.
All right, I'm approaching now Ms. Thomas, and I'm showing her what pre-marked as States Exhibit 5 and 6. If you would, please, we'll start with 6. Do you recognize that document?
Yes,
What is that document?
this is a protective order.
All right, get ready to screen share. All right, and do you see the caption on that first page? The petitioner and respondent information?
Yes.
All right, and who is the petitioner?
The petitioner is Malika Thomas, Elizabeth Bryant, Olivia Bryant, Bryce Bryant.
Is this the TPO that you were thinking of on April 30th, 2020? Thinking that Mr. Bryant didn't have a reason to be there with you?
Absolutely.
All right, and is that document that you're holding now a fair and accurate copy of the TPO that was issued
Yes.
All right, are there any alterations, deletions, or additions that you can take notice?
No.
All right, Your Honor, this time state will move to the tender and evidence States Exhibit 6.
Ms. Wood, any objection to state 6?
No objection, Judge.
Admitted.
All right, permission to publish, Judge.
Yes.
All right. All right, ma'am, I'm going to share now that document with you. Are you able to see it on your screen?
Yes.
All right. Now, I'd like to direct your attention again, look on the screen or, here, let me just have this for a moment. Or the document that's in front of you. But who is the respondent in this TPO?
Stuart Bryant.
Okay. And is that the Stuart Bryant in this courtroom today?
Yes, sir.
All right. Now, if you'll take a look on the first page of that document, paragraph 3, could you read that to the jury, please?
This order shall be in effect for up to 12 months from 6/19/2020 until 6/18/2021.
All right. And turning to page 2 of the document, if you would, and looking at paragraph 7, can you read that to the jury?
Yes, the petitioner is awarded sole and exclusive possession of the residence at 3286 Sir Henry Street, East Point, Georgia, 30344.
Okay. And is that the address of the house where you were having that birthday party on April 30th, 2020?
Yes.
All right. Now, if you take a look then also at paragraph 11,
Yes.
if you read that to the jury, please.
The respondent is restrained and enjoined from approaching within 200 yards of petitioner and or petitioner's minor children.
All right. Now, on that day, April 30th, 2020, did Mr. Bryant, the petitioner, come within 200 yards of you? Excuse me,
Yes,
the respondent come within 200 yards of you?
yes,
All right. And did Mr. Bryant come within 200 yards of any of your minor children?
yes.
Okay. Who did he come within 200 yards of your minor children?
All three of my children, Elizabeth, Bryce, and Olivia.
All right. Now, are you aware of Mr. Bryant assaulting your daughter Elizabeth Bryant that day?
Yes,
All
I was
right.
made aware, yes.
Were you present at the time that occurred?
I did not see it happen.
Okay. Did you hear that assault?
Parts of it, yes, I heard the aftermath of that, yes.
Okay. What did you hear after that, and who did you hear that from?
I heard my daughter and her father arguing back and forth, and I heard him, call her out of her name.
And
And
what is, all right, so first of all, you know what they were arguing about based on what you heard?
him being in the house and him being disrespectful.
Okay. And then you said calling out her name. What does that mean?
He called her a few expletives.
Okay. What did he call her?
Oh, he called her a whore. He called her a hoe.
And that's his daughter.
That is his child.
Okay. All right. Now, let's return to where you're downstairs, and Mr. Bryant has come up to your face. Are you with me?
Mhm.
All right. At that point, what do you decide to do?
Go call the cops.
All right, why?
We wanted him to be gone. I wanted him to leave.
And did you ask Mr. Bryant to leave?
Of course.
Okay. And at any point, did he listen to you?
Absolutely not.
Did you ever leave the house or the property?
Only when the cops came.
And while y'all were waiting on the cops to come, what was Mr. Bryant doing?
Just, arguing, fussing, just pretty much telling us to get out of his house, that I was going to jail, that we are destroying his house, and he didn't give a F about what was going on in the house, what we were doing, so he just wanted us to get out, apparently.
How did this affect the mood of the party?
It just dampened it for a little while, for the duration of the time that he was there.
About how long did that last from the time he arrived until he was removed from the property?
I want to say maybe in 35, 40 minutes, not longer than an hour, I don't think.
Did the police arrive?
Absolutely, yes.
All right. And do you know which agency arrived?
East Point, the city of East Point.
And did you have an opportunity to speak with any of the officers who arrived?
Yes.
All right. What did you tell the officers who arrived on scene?
I told them what had happened and that I had a protective order against Mr. Bryant. And then I gave that to them. Yeah.
And so are you saying that you had a copy of that order?
Yes.
And the copy of that order you had that day, is it the same order that's been admitted into evidence, States Exhibit 6?
Yes.
All right. And did you provide that to the officers?
Yes, I did.
Right. And did you tell the officer about what he had said and what he had done in the house?
Yes.
What did you, I just have one moment. And while you're speaking with the officers, where is Mr. Bryant? You recall?
I think at this point they had taken him outside of the house.
You know where he was outside the house?
In the front yard, in the front.
And where were you speaking with the officers?
That at one point I was in the house, and at another point we were all standing outside.
All right. And did you speak with one officer or two officers? Do you remember?
I only really remember speaking to one officer. Yes.
All right. Let's back up a little bit and go back to the 911 call. You called 911.
Yes.
And what was the reason that you called 911?
Because Mr. Bryant was in the home and he shouldn't have been there.
Okay.
Yeah.
All right. And I want you to take a look at States Exhibit 5. Do you recognize that item?
Yes.
Okay. How do you recognize that item? What is it?
It's the 911 call.
And have you had an opportunity to review your 911 call?
Yes.
All right. And was it a fair and accurate recording of the call that you made that day, April 30, 2020?
Yes.
All right. And were there any alterations, deletions, or additions to that call?
No.
All right. And how did you acknowledge that you had listened to
that 911 call on that disc?
I initialed it and put the date on it that I heard the recording.
Your Honor, at this time, state would move to tender into evidence State's Exhibit 5.
Any objection to States 5?
No objection.
5 is admitted and may be published.
Judge.
East Point 911, operator 97.
Please, can you please send a car or cars to 3286 Sir Henry Street, please?
They are en route.
There's a young man here that I have a restraining order on. I'm having my son a birthday party. He is disrupting. Please, please, please,
Ma'am,
please.
they are en route to you. They are en route.
Thank you.
They should be there shortly. All right.
Is that the 911 call you made that day?
Yes.
And what were you hoping 911 police could do for you?
Come and get him. Just make him leave.
And ultimately, did the police come and get him and make him leave?
Yes,
And what did they do to do that?
they arrested him.
Were you there to observe that?
Yes.
And where did they take him after they placed him under arrest?
They put him in the back of their car and they drove off.
Were you able to resume the party for Bryant after that?
Yes,
And we all able to have fun?
yes, my son enjoyed himself.
Earlier in your testimony, you testified about how you were married in 2004, Mr. Bryant, is that right?
Yes,
And so in April of 2020, you had been married for about 16 years,
yes,
is that right?
yes.
All right. And during your marriage, were there other instances in which he was violent toward you?
Often and all the time.
All right. Well, let's try to focus on a couple of incidents, okay?
Okay.
I want to direct your attention to the year 2015.
So I'm going to pause you for 1 second. I want to remind you, ladies and gentlemen, we're about to get into a discussion of what I had called those other acts. So you may hear testimony about things that Mr. Bryant allegedly did. And you can consider that evidence only insofar as it may help you assess any intent or motive in connections with the two crimes that Mr. Bryant is on trial for here now. He is not on trial for any of the specific incidents that Mr. Whitenauer may explore with Ms. Thomas. He's free to do so. I just need to remind you all, and I'll remind you at the end of the trial as well, the limited purpose for which you may use the evidence about which you're going to hear.
Ms. Thomas, let me again redirect you to 2015. Do you recall a violent incident which resulted in you being injured?
Yes.
Okay. Can you tell the jury a little bit about what preceded that assault and that subsequent injury? What was happening between you and Mr. Bryant?
It's just kind of hard to kind of relive those times, but
Was there an argument that led to an assault, Ms. Thomas?
mhm.
Do you remember what that argument was about?
I recall what the argument was about.
It was in 2015, right?
I do remember that incident, yes,
Right.
where I'm on the ground and he's kicking me and yeah, just screwed up my ankle, couldn't quite walk for a while and
How did you find yourself on the ground?
he's a big guy, he put me there.
Okay. How did he put you there?
Hitting, grabbing, putting me on the ground and kicking me.
Where was he kicking?
stomach, legs. Yeah, because I was kind of curled. So,
Remember where this occurred, Ms. Thomas?
yeah, outside, front of the house.
Which house?
Not at, I think this one was at Carla Woods, perhaps,
At what?
at the other home that we lived prior to,
I think the judge is trying to get you to repeat that street name.
Carla Woods,
Carla Woods?
Carlo.
Carlo Woods. Okay, thank you.
Was that out the front of the house?
Yes,
Alright. Were there bushes in front of that house?
yes,
Remember there being some bushes in this assault?
yes.
Tell the jury about that.
I was pretty much tucked off into them, being kicked and hit and called names.
What names did he call you?
Pick one, bitches, the whole, whatever he could come up with.
What his names he would call you?
Often. Mhm.
Do you sustain any injuries as a result of that assault?
Yes. Yeah.
What injuries did you sustain?
Outside of the bruises, I couldn't quite walk for a little bit. My ankle was kind of swollen and yeah, couldn't,
Ankle.
right ankle,
Were you working at that time?
absolutely.
And what was your job then?
At that time, I was a bartender. So,
And as a bartender, do you have to stand or sit?
absolutely. Stand, yeah.
And how did that injury to your ankle affect your ability to do your job as a bartender?
I did it in pain, wrapped tightly and just kind of sucked it up like I always did, go to work.
Tell anyone about it?
I tend to keep things. You know, keep them.
I want to redirect your attention now to February of 2020. Do you remember another incident in which Mr. Bryant assaulted you?
Yeah, getting ready to leave for work.
Let me see. So we're going to talk about two more incidents, one in February of 2020 and one in March 2020. In February of 2020, do you recall an incident about your phone?
Yeah, sitting in my room, having a conversation, door locked.
Let me stop you for a minute. Which room?
My bedroom. We at this point are separate bedrooms. I'm downstairs, he's upstairs.
Which house are you in?
This is at Sir Henry.
And is your bedroom upstairs or downstairs?
My bedroom is downstairs.
And where were you in your bedroom?
I was in my bedroom sitting on the bed, talking on the phone.
Anyone else in the room with you?
No.
The door open or closed?
Closed and locked.
Why did you lock the door?
Always lock the door when I know, that, the steward is there. Just keep it locked. Feel safe that way.
And at that time, were you communicating with Mr. Bryant? You had your phone, were you talking with this person and maybe texting with Mr. Bryant or anything?
No, I was talking on the phone and he proceeded to kick the door in and, take the phone, and if, of course, tussle ensues. I called the cops, and I think that particular time I ended up leaving the house.
What did he do with your phone?
Went through it, just, went through it, messages or, just being steward.
Okay. What was he saying to you while he did that?
Of course, name calls, fucking whore, who am I cheating with? What am I doing? Just things.
And did he strike you?
Yeah, that's
How did
common.
he strike you?
With his hand. He's always hitting me with his hand.
Where did he strike you?
My face.
Right.
And it was open-handed, yes.
Sorry?
Slap, yeah.
Say open-handed?
Yes.
After he took your phone and slapped you, what did he do?
He took the phone, he went outside around the side of the house, and we called the police from my daughter's phone.
I want to redirect now your attention to March of 2020. Was there another incident in which Mr. Bryant assaulted you?
Yeah.
All right. Now, what was happening that day before the assault?
Well, that day, it was just, I was getting ready to, had gotten my hair braided or was getting my hair braided, getting ready to go to work. And he was trying to like physically restrain me from leaving the house. He would like box me in, like, he's a little bit taller, a little taller than I am. And he would like box me in and put his hands like.
Now, when you say he was boxing in, let's talk a little bit about it. You say he's taller, is that right?
Taller than I am. He's larger than I am.
Do you know if he's heavier than you?
Yeah, and at that point, he was about 100 pounds heavier. I've gained a little weight. I was about 160. He was about 260.
Okay. And was he stronger than you?
Absolutely.
And where in the house is he blocking you or boxing you out?
I'm trying to leave. The door is here in the corner, just kind of in the corner, in my face, just, yeah,
Okay.
just, and
And your hands are up. Was he touching you by your shoulders?
I wish they were my shoulders, but yeah, pretty much.
Was he touching you other places?
Yes.
Yes or no?
Yes.
Okay. And you said that you were in a corner, is that right?
Yes.
Was that in a room or a hallway?
In the front of the house, like in the foyer where the door is, trying to leave, just in the, corner,
Did you explain to him what you were trying to do?
of course.
And what
Don't
did
touch
you-
me, let me go to work. Just let me leave, just let me leave.
Okay. And where were you trying to go to work? What was your employment at that time?
Same thing, bartending.
All right. And were you able to eventually move from that corner to another location?
He eventually let me leave.
Okay.
Eventually,
Were you able to get to your car?
I was able to get to the car.
All right. Did anyone follow you to your car?
He followed me to the car.
Who?
Stewart.
All right. And where were you in the car at that time?
I was getting into the driver's seat, and I used like these pillows to sit on to make me a little bit, see over a little bit. And they were his pillows. He proceeded to take the pillows and, of course, continue to curse. Door still open. I just decided to kind of try to back out and just go.
How tall are you?
I am about 5'3".
Okay. So you need a little bit of help seeing over
Just
over the
sometimes
dash.
when it's a big car, yes.
All right. I understand. What kind of car was it then?
It was I do believe I had a Suburban at that time.
And while you're trying to back up, where is Mr. Bryant located?
He was at the door, like had the door kind of open, and then he kind of eventually stepped back and let me go.
Was there a pressing matter that he needed to speak with you about then?
No, just wanted to make sure I had a bad day. That's all.
And did you have a bad day?
You just kind of put it in the back, just tuck it away like you do everything else.
Is that what you usually did?
And you put your smile on and you go on about your day.
Did these prior acts, did they cause you emotional distress?
Completely.
Objection, Judge, relevance.
Your Honor, it is relevant. I anticipate that Your Honor will be providing instructions about what harassing and intimidating means. And the state has to address all those parts of its definition to prove its case beyond a reasonable doubt.
Okay, overruled.
Did those prior acts cause you emotional distress?
Absolutely.
And did those prior acts cause you reasonable fear for
Absolutely.
yourself?
Yes.
And on April 30th, 2020, did his behavior cause you reasonable fear?
Objection, Judge, leading question.
He's orienting the witness to a specific time. Once you finish the question, please don't answer it, Ms. Thomas, till I hear the whole question, and then I'll evaluate your objection. Sure.
On April 30th, 2020, were you in reasonable fear for your safety or for the safety of other members of your immediate family?
Okay. You overruled, you may answer the question.
Yes.
Why?
Because you don't know, with the with the patterns and what you've become accustomed to. You just don't know how someone is going to react, and he's, angry and, you're just afraid. It's just, you don't want to be hit anymore, Yeah, you don't want to see that for anyone that's, within the vicinity, yeah, just.
And was Mr. Bryant there on April 3rd, 2020 to participate in that birthday party?
Absolutely not.
I may have one moment, Judge. Thank you, Ms. Thomas. I don't have any more questions for you. Defense counsel might have some questions for you now.
Ms. Wood, questions for Ms. Thomas?
One moment, Judge.
Okay.
Hi, Ms. Thomas. The 3286 Sir Henry Street address was jointly owned by you and Stewart, correct?
Yes,
It's still jointly owned by you and Stewart?
yes.
You answered on direct that while Stewart was at the property on April 30th, he looked into a bedroom. It was his bedroom, correct? The one where he stayed?
Yes.
And you mentioned the cooler. Was that also his cooler?
Yeah, sure. It's cooler.
Can't believe she's asking these questions. State talked to you about the order from June 19th, 2020 to June 18th, 2021. You're familiar with that order?
Yes,
And you're familiar that it was never properly served on Stewart?
no, not aware of that.
Are you aware that most of the things that were sent to him via mail came to the Sir Henry address during that period of time?
What are you asking?
I'll rephrase.
Okay.
After he left the property in 2020,
Right.
he still received letters and mailings to the Sir Henry address, correct?
I think so, perhaps. Yes.
Even though he had vacated the property, correct?
Yes.
How would you get him if, say, a bill from Allstate in his name came to the Sir Henry address? How would you make sure that Mr. Bryant got that letter?
I would assume that Mr. Bryant would have gone to the post office and made a change of address for his mailings. Usually the things that come there are ads. There is not anything that's, that's mail.
Okay, so my question was a little different, but it sounds like if something did show up at the Sir Henry address in Mr. Bryant's name, and it wasn't junk mail, didn't appear to you to be like Domino's pizza coupons. Did you have a way in which you got those things to Mr. Bryant, or it was just junk mail?
I didn't have a way to get those things.
Okay.
You answered previously that Stewart came to the home, words were exchanged, and then you called 911, correct?
Yes.
Why did you wait to call 911?
I don't know. I think it was the shock of it all.
While you were waiting on police officers to show up, you were still engaging with Stewart, correct?
I was standing there, not necessarily engaging.
There was still conversation
still-
going on?
Yes.
A little bit of back and forth?
Yes.
Okay, make sure you guys don't, that was innocent there, but make sure you don't talk over each other. So Ms. Wood, wait till Ms. Thomas is done, and Ms. Thomas, wait till the full question comes out before you answer.
Okay.
Thank you.
Thank you, Judge. You also mentioned that the atmosphere at the birthday party was dampened for a little while, correct?
Yes.
But the party continued,
Yes.
even after Stewart was taken off in handcuffs?
Yes.
So he was there for a moment before the officers actually came, correct?
I would, yeah, maybe 20 minutes, 30, yeah, 20, 30 minutes perhaps.
You also testified that he was violent often and all the time, correct?
Yes.
But you sometimes engaged in a back and forth with him, correct?
What do you mean by that? Arguing, verbal?
Correct. If he's
Yes.
arguing, you
Yes,
went back with him?
yes.
You? Mr. Whitenauer spoke to you about some allegations from years back,
Yes.
correct? But Stewart was never charged for any of those allegations, correct?
Right.
He was never arrested for any of those allegations?
No, a lot of those didn't call the cops.
And that 2015 incident where you were injured, you didn't go to the hospital, correct?
No.
So there would be no medical records for that. And there were no witnesses for any of those incidents?
Just my children.
And that 2020 incident where Mr. Whitenauer spoke to you about you being on the phone, you and Stewart were separated. You were living in the same house, but technically separated, correct?
Right.
And you're aware that Stewart took out his own version of the temporary protective order in April 2021, correct?
I was made aware of that, yes.
When were you made aware of that?
When was I? There was an incident where I think I was at work, I know I was at work and my kids called me and said that there were cops at the house. And I told them to just go ahead and open the door to see what was going on. And I actually spoke on the phone to one of the sheriffs. And he was explaining to me about an order of protection.
And it's an order of protection that required you to stay away from Mr. Bryant, or it was about the one you had to keep Mr. Bryant away from you?
I think it was maybe perhaps one that he had filed, because I never received the document. I never physically saw the document.
One moment, Judge.
Mhm.
Yeah. Mhm.
Thank you. Ms. Thomas, so it's your testimony today that you never saw the temporary protective order that Mr. Bryant, my client, filed against you, correct?
Right.
Thank you. No further questions, Judge.
Any redirect, Mr. Whitenauer?
May I have 1 moment, Judge?
Sure.
Yeah, I think I want to do that. I see it's filed in June, but May of 21. That's a mistake. But it's okay. I'm going to do it.
I get what you're doing. You want a sticker?
Yeah.
Stickers. Oh, you got it.
It may be that it would be a document from the clerk's office. Yes, Your Honor, and I think before we proceed, there might need to be some argument outside the presence of the jury about an exhibit.
Okay, why don't we do this? It is almost 3, which is when I was planning on having our afternoon break. We're moving along at a real healthy clip with the state's presentation. So we'll start your afternoon break, ladies and gentlemen of the jury, a few minutes early. I'm going to try to keep it to about 15 minutes, but I need to give the lawyers a break as well. And the first few will be talking about what we need to talk about outside your presence. So enjoy the break. Remember, you can use that hallway. Don't talk about the case. No outside research. And we'll bring you back here as close to 3:10 as we can. Thank you so much.
No, because he hasn't been arrested.
Yes, hold on. Don't go anywhere yet. Logistical questions. Take them with you. Yeah, you're welcome to leave them right there. No one's going to mess with your cards. So just make sure you collect your cards to hand to Deputy Gordon when it's question time. Okay? Well, all right. And Ms. Thomas, I'm gonna have you step outside as well, so you get a break. And someone from the DA's office will let you know when the break is over and you can come back in. Thank you. No, you go toward, I think the deputy went with the jurors. You go out the way you came in, please. All right, let's talk about the item. First, what is it?
Your Honor, Judge, it's going to be the order of one petitioner's motion of contempt if I can grab it.
Yeah, can I just have it?
Yes.
I mean, I'll give it back to you, but let me see what we're talking about.
Yes, so it's for the same civil case number on the TPO that was previously admitted to state 6. And the state intends to
So that order comes from the Fulton County Clerk, so in this courthouse, and we'd be asked to take judicial notice of it. And we would offer that to rebut the inference that was being made on cross of Ms. Thomas that Mr. Bryant had obtained his own ex parte TPO against her. The inference being that somehow she should not have been at that address, that she should not have been having contact with him. But this would rebut that inference, showing that in fact, upon the motion for contempt, he was found to be in violation of the TPO order that was admitted as 6.
Okay, so what I see, state 7 is an order signed by Judge Manning in July of last year that says Judge Manning found Mr. Bryant in contempt of her TPO, which is state 6 and is already in evidence because Mr. Bryant basically did what this case is about. I think the dates are wrong because it says May 2021.
It was on May 1st, Judge.
Okay, so very end of April, early May. But it seems like it's the same situation because it mentions that Mr. Bryant was charged. How does this show that Mr. Bryant did not have a cross TPO against Ms. Thomas?
Well, Judge, because I mean, I don't think it shows that there wasn't a cross TPO. I think they can make that argument, but they're also making the argument that she somehow, because of this cross TPO, was in violation of TPO. But that's not the case. And there's a judge who issued that TPO found that she wasn't in violation of that of some other TPO, that this defendant was in violation of that TPO.
Okay. What is the defense response to whether state 7 should be admitted? Oh, Ms. Feely,
Hello. Nice
welcome back. It's very nice to see you.
We would say that this is not relevant for any purpose in relation to this case. It contains hearsay and opinion evidence that just is not relevant to this particular case. And if it's cumulative and it says he's not in willful contempt. So this whole document that we believe is not admissible on a number of grounds.
It also kind of treads upon ultimate issue questions. It does have the term aggravated stalking in here. It doesn't say that what happened was, but that it could in the future. But most of all, I think at this point, and this is more a cautionary observation to the defense, I don't think it rebuts anything that the defense has been probing at, in part because there is not yet a defense exhibit in that is Mr. Bryant's protective order that he obtained against Ms. Thomas. All that is of record, not what lawyers say, but of record, is Ms. Thomas saying, I think I heard about it. I never got a copy of it. So I don't think that right now in the record is evidence that Ms. Thomas in any way thought she was violating any order. The only order in the record is 6, and 6 says unequivocally, Ms. Thomas, this is your property and not the defendant's. And so based on the record right now, the defense couldn't make a factually supported argument that there's no aggravated stalking because he was actually at his own residence, which is an exception to aggravated stalking. If you're at your own space, you don't commit aggravated stalking if you violate a TPO. But the TPO that is allegedly violated makes plain that Sir Henry was not Mr. Bryant's space. It was Ms. Thomas's. So I think right now, you're gonna need to keep your powder dry on 7. It is a court record. I can take judicial notice of it. I understand it's not a certified copy. I'm sure you could get one. But at this juncture, I don't think it comes in. It may, depending on if there is a defense case presented, become more relevant or sufficiently probative that it comes in. But right now, I don't know that it's so much hearsay. It is a court record, and this is a court record and has arguably hearsay in it as well, state 6. But I don't think state 7 is directly on point to the concerns you've raised. And then there's that ultimate issue concern I have as well. There may be a redacted version of state 7 that could be used depending on where the defense goes with, if they go anywhere, with the order that Mr. Bryant contends he obtained. And it sounds like it's in the docket, so it happened. Right now, Ms. Thomas has said, I heard about it, but it's nothing I was ever served. Does that make sense? Okay, all right. I'll give that back to you. I'm gonna give you all a break. You can have 6 too, but it's in the record. Anything else, Mr. Whitenauer, from the state before we take a break?
No, that was fine, Judge.
Okay, anything from the defense?
No, Your Honor.
All right, I have to be on a Zoom call for about 10 minutes. And then we'll resume with Ms. Thomas's testimony. Is there going to be other redirect? I know that I've shut the door for now on 7, but that doesn't mean you don't have other redirect.
Yes, there, some.
Okay, so when we get back, just so I'm oriented and I can orient the jurors, it will be redirect of Ms. Thomas, and then apparently there'll be a bunch of juror questions. All right, thank you.
Why can't we have that also? Yeah, I didn't get it in that way. Yeah. I'm gonna do that. I'll do this.
I'm glad to be here. I never 19. I was like,
So I'm gonna go do this right here. Just over here.
Cheers. I had no idea she was gonna be out there.
What if I got quieter candy? Just like, I don't know. Facing us again.
I just got a receipt out of it.
You did? Good, that's what they're there for. There's Reese's in the bottom. Yeah, I'm just like trying to consolidate. There's also some like the children's applesauce squeeze packs, like where you don't need a spoon if you want that. And I've got some freaking like Nutrigrain, whatever bars.
Oh,
with
you
peanut.
got everything. Thank you.
I am almost off of almost orange slices. I've like been watching on the YouTube. It's good background noise, and also like, I like watching trials. And like, any background noise. Like. Scrolling down. I say that he's my intern, he was my intern last summer, like, he was like, he's still my intern, he's my son. He's not really my son, I call him my son. Oh, it's Kansas, Andrew Rogowski. Yeah, my child.
Hey, Lee, I'm sorry to hear about your house.
I got your very sweet message.
Yeah. Well, I'm so sorry. I had a house fire in 2018, so I know how terrible it is. And if there's anything that we can do for you or get for you, please let us know.
Oh my God, he showed up. I don't remember it. I changed my clothes.
Well, you and she have great taste.
Her shoes are a little big, but a little shorter than she is.
Well, I remember the morning after our fire, I had a deposition. I was in Korea at the time. It was kind of workers' comp. And so I showed up in a jacket and pants that just reeked of house smoke.
Man.
So it was an interesting appearance, but you know, it's a long road ahead. And if you ever want to soundboard on like that process, and you might just not want to talk about it all to anyone, but yeah.
It started kind of in our bedroom, so
Yeah.
it's a total loss of all of our clothes and shoes. But, you know,
New wardrobe.
it can be replaced, exactly, it just takes time to get
Yeah.
all that stuff back together.
Yeah, it does. We were out for about 6 months. So we got the house. We built, I'm guessing that I understand what total loss. Yeah.
Yeah, even down to like the kids.
Yeah. I can't believe it took them that long to get there. Oh,
Because,
yeah.
you know, like, it feels like an eternity, when that was like 10 minutes, but.
Oh, yeah. Yeah.
In hindsight, I wish I had done more to like shield the kids like from it, but, I mean, we were watching, because what do you gotta watch, you know?
Right. I mean, my kids wanted to watch the fire engine too.
Yeah.
Because it's cool. You're like,
How old
well,
are
that's
they?
not that cool. Let's see, it's 2018. So my oldest would have been 3 and he
Oh, wow.
vaguely remembers it. And then we had yeah.
Were you guys home?
Yeah, we were home, we had smoke detectors, and I woke up and the fire was running up the wall, and I tried to put it out with the fire extinguisher, it did not work.
Once
And
it gets going, it's
Yeah.
so hot.
it pretty much had reached into the back.
Yeah, that's exactly what happened.
Nothing you can do.
Once it got to the attic, it just
Yeah. Yeah,
ran through the building.
well, I about the year saved a lot.
Exactly.
That's
Very
good.
easy to keep priorities, because there was a house fire that same day,
Mm.
like 2 kids
Mhm.
calling out, so that seems like if I start to be like, oh, my suits, it's like.
Yeah. Sure. Well, I was just joking, we got 2 new bathrooms, so we'll get some eventually, once all the construction insurance is done, some new digs and a new suit. So anyway, let me know.
Thank you so much.
David, can you call him? No, just.
I love it though.
I feel like I'm back in, I don't know. High school, junior high, something, going on like a field trip, maybe. I wonder if military guns were really.
When we do 3 lines upstairs, we can turn them on.
I didn't redact, I put the marker there, so the judge can tell you what to redact.
I told them to take that on redirect.
Yeah, like that.
I want to. Well, he's gonna say, well, that wasn't part of your direct. I wonder. Yeah.
Nobody ever asked
The
for
questions.
Yeah, I know. It's in those situations. Not around here to keep a secret.
So.
I wrote it in yours.
Well, I mean, but aren't you allowed to do on this stuff that they've been doing? Well, they went into.
Should have brought down the ones.
Not about petition.
Grocery store.
But
It's like-
it's okay, you can say that, you can say that.
Orlando.
This is their last opportunity, they've not done it now. It's gonna be him, if he does, okay, that's fine, and then we get to do the like proceedings, and then we get to do, and, but. That's fine. He went there. And this was consistent with just. I think so. I'm doing say what? They never said. We know that. Ooh, what extent is protectable for 3 years? What's the difference between finding or violating and what being with contempt? So let's let them know. Yeah. So you're representing the court after this, right here. And you're also there was a petition for what you can take, right? And you were represented by an attorney, right? And that's Judge Brown, it did violate. But how do we, what?
Are we okay?
Yes, sir.
We're good, okay.
Just doing well.
All right, welfare check, good. Do it more often with this Gordon guy. Ms. Feely, how are you?
I'm doing well. I was pleased to know I can wear Miss Perfect's clothes.
I bet she's pleased. Yeah, it's quiet. Yeah, no, it's nice and quiet. It's not gonna, this thing, tack, 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 tack. So it won't go over the Zoom feed and all that.
Okay.
Mr. Whitenauer, can you get Ms. Thomas back in here, please? Well,
Yes.
before you do that, is there anything we need to get on the record outside Ms. Thomas's presence?
Well, Judge, I wanted, if I might, if the.
Try again?
Yes.
Sure.
So Judge, I would like to inquire of Ms. Thomas on redirect about what actions she took after May 30th, 2020. And specifically about, and I anticipate that she would testify that she filed a petition to hold the defendant in contempt for violating the TPO. And I'd like to ask her about that. And if she answers in the affirmative that she did, I'd like to ask her if she's aware of whether the judge in that case then issued an order on that motion for contempt and then tender into evidence State's Exhibit 7 with any redactions Your Honor deems appropriate to address any ultimate issue questions. And I'd also like to then tender what I'll be marking as, or is marked as State's Exhibit 8, the Family Violence 3-year protective order, which is mentioned in that order on petitioner's motion of contempt.
How do you navigate the finding by Judge Manning that she does not find the defendant in contempt in the order of contempt?
Well, she finds that
He violated the order.
Right.
But he's not in willful contempt. So, let me tell you, defense, what I'm inclined to do. Well, what I'm thinking about doing, but I'm a little nervous about letting someone share with the jury that some other judge has already decided this case. But it is factual that Judge Manning said, hey, he violated the protective order that I signed. I don't think that document needs to come in because it's confusing. It talks about aggravated stalking and actually says, I don't find you in willful contempt, even though it says order for contempt. But it does say, I find that you violated the order. And so I don't know what Ms. Thomas knows, but let's assume for a moment she remembers, yes, after Mr. Bryant pulled this stunt at my house, I sought a court hearing, I got one, and the judge found that Mr. Bryant had violated the protective order. Tell me what your objection is to that, Ms. Feely.
Thank you, Judge. First of all, we're going to renew relevance on this is something that happened after April 30th of 2021. And so I don't know what relevance it would have as to anything that to do with what's in the indictment, but I think the court hit the nail on the head with the bigger issue of it invades the province of the jury with the factual finding, basically, that Mr. Bryant violated the TPO.
What is the relevance, given that this happened a few weeks or months after the incident? It is some other judicial officer commenting on really what you need to prove to this jury, which is not only did he violate the TPO, you have an additional burden that it was for the purpose of harassing and intimidating, et cetera. But how is it relevant that later on a different judge in a different setting, although Mr. Bryant was represented by counsel during that proceeding, made the finding that you want to share with the jury?
It's relevant because it goes to her credibility as a witness and her fear of this defendant from this violation of the TPO in combination with the prior difficulties and that pattern of intimidation and harassment. So her having this experience with the defendant, the respondent in the TPO, coming to her address during that birthday party, her fear from that incident and her credibility in stating that caused her emotional distress and fear for her safety. Her credibility is established further by her being able to testify about how after this she was still concerned about her safety, that she then went back to that same judge and said, "Judge, he's violated that TPO. I need protection. I need help." And that judge heard her while the defendant and the respondent was represented by the public defender's office, found that he violated that family violence order, and further issued this family violence 3-year protective order. So it goes to her credibility. Credibility is always relevant.
So where we are now, I am comfortable letting you ask Ms. Thomas if, as a result of the April 2021 incident at Sir Henry, did she go back to court in connection with the TPO she had? And I think her answer would be yes. And as a result of that court hearing, did you get an additional or an extension of the TPO? I think the answer is yes, and you would be able to introduce what would probably be State's 8 if you've already labeled it, which is that 3-year extension of the TPO. But for now, I am going to have you stay away from, oh, and by the way, Judge Manning found that Mr. Bryant had violated the TPO. I think you get to her, you support her credibility in the way you've described, and you're entitled to do that by discussing the extension and the fact that as a result of this, this was something that intimidated her and she felt sufficiently harassed that not only did she call the police, but days or weeks later, she went back to court to say, look what happened. I think that's part of your burden and you're able to get into that. What I'd like us to stay away from now is any mention that in some other legal setting, a judge said that Mr. Bryant violated the protective order. I'm not closing the door on that because I think analogously, if Mr. Bryant were charged with a felon in possession of a firearm, you prove the felon part by showing that some other judge at some point adjudicated Mr. Bryant guilty of a felony. And it is not a defense. It's like, whoa, that's the ultimate issue. Well, no, it's an element of the crime. And one element of the crime of aggravated stalking is that Mr. Bryant violated the TPO by showing up at Sir Henry when Ms. Thomas and her kids were there and he got within 200 yards of them. That's an element that there was a violation. Arguably, you've already proven it. I don't find it to be cumulative. It's just, I'm not sure that I'm troubled by it. Not that you're doing anything inappropriate. It just, to me, it bleeds into that ultimate issue. It would be like Judge Manning entering an order saying, I don't find Mr. Bryant to be credible. This jury is going to decide if Mr. Bryant's credible if he testifies and not a different judge. So do you understand what I'm letting you explore with Ms. Thomas?
I understand the court's ruling. I will limit my redirect of Ms. Thomas to questions about her returning to the court after this incident in connection with the violation of TPO.
And it won't be leading for you to say, and as a result of that hearing, did you get some kind of extension or expansion of the TPO? And then you can tender that document.
And Judge, we would have, just so we get all the objections on the
I'll
record.
let you object in a minute. I just want to make sure that Mr. Whitenauer understands where he can go and where he can't. It sounds like you do.
Yes, Judge, I understand your Honor's ruling. And last note, I would be seeking to tender into Evidence States Exhibit 7, which is a copy of the filed order from Fulton County Courthouse. And so I'd ask that you take judicial notice of it.
That's the 3-year extension.
It is.
Okay, all right. Ms. Feely, perfect the record from the defense side in terms of how I'm ruling on this. And you understand we're staying away for now from Judge Manning's order, not finding your client in contempt, but finding that he violated the TPO. That order is not going to be tendered and admitted. There can be a discussion about the fact that there was that hearing, but not Judge Manning's findings, other than that it yielded what you have in your hands.
So I think the problem with that, Your Honor, is that it is a legal conclusion, that even the fact that there is another order, and it's not based on any other further conduct by Mr. Stewart after the May date. So he didn't do anything, he's not alleged to have done anything else. In the meantime, this document is hearsay. It's a court saying that he basically violated, if this is allowed to come in.
So I haven't read it. If what that order says is I, Judge Manning, am extending this by 3 years because I find Mr. Bryant violated the order before, then I'm not saying Mr. Whitenauer is doing this surreptitiously, but that's backdooring what I said shouldn't come in. I assume that looks just like the original TPO, but it's got a 3-year duration. And if it looks just like the original TPO, then I don't think it's not hearsay. And I also don't think it's Judge Manning saying you violated anything. It's Judge Manning saying, I've heard you, Ms. Thomas, tell me about what happened. And so I'm going to extend the protective order. And so one could infer what you're saying, but I don't, unless I haven't read it. So I don't know what it says. Did you see language in there where Judge Manning says, because Mr. Bryant violated the original TPO?
So it's based on the hearing that was discussed here. So I think for the jury to hear that a judge then extended this is, I think that's a legal conclusion that is going to invade their province again. I don't think that it is indicative of anything other than a judge found him in violation of the TPO, which is what they're here to decide. So any further rulings, I think, is going to infringe on Mr. Stewart's ability to or Mr. Bryant's ability to get a fair trial, because they are going to hear a judge already dealt with this in the form of issuing yet another protective order.
Yeah, I guess it could cut both ways. If the judge already dealt with it, then the jurors may say, we don't need to deal with it. She got another protective order. But as long as I am not hearing from a witness or a prosecutor that the 3-year extension flowed from a finding that there was a violation of the TPO, as opposed to the way the state's going to need to characterize it, which is Ms. Thomas was so upset and harassed and intimidated by what happened in April of 2021 that she went back to court and she got an extension of the order, then I hear your concerns, but I don't think that that way of presenting it actually triggers those concerns, or doesn't sufficiently that I'm going to keep it out. So you've made the record. Mr. Whitenauer, you've got some guardrails you'll need to observe. And unless there's anything else, I'd love to get the jury back in here. Anything more from the state?
Nothing further from the state.
Ms. Feely?
Yeah.
All right.
Yeah, bring it back.
Listen to the keyboard. You can't, because it doesn't make noise. What a wonderful development. Yeah, but you're not typing on that when you're taking stuff down.
All right, Ms. Thomas, go back to the witness stand and you can have a seat just like you were before, okay? All right. I got right here.
All right, adjourned. Joseph present.
Thank you, Deputy Gordon. Everyone else can be seated. Thanks for your patience. We ended up having 3 legal issues we needed to work through, some before I gave everyone a break and some after, but we are ready to pick up where we left off. Ms. Wood had completed her cross-examination of Ms. Thomas, and I had asked Mr. Whitenauer if he was going to redirect, ask a few more questions of Ms. Thomas, and then there was something he needed to talk about outside your presence. We've now done that 3 times, and we're going to move forward with the redirect.
Thank you, Judge. Ms. Thomas, how did you feel after Mr. Bryant came to the house at 3286 Sir Henry Street?
The day of the party?
And if it's okay with you, if you're comfortable, maybe you can take your mask down and just remember to scoot forward a little bit, lean into that mic.
Okay.
It's okay, take your time. Did you lose an earring?
On the back of it, it'll be fine.
Okay. All right, and just kind of try to raise your voice up a little bit for the jury. So how did you feel after Mr. Bryant came to the house?
I felt threatened, felt afraid. It brought back a lot of feelings. I felt slightly helpless, but.
As a result of that incident on April 30th, 2020, did you go back to the court in connection with the TPO?
After
the incident, did you go back to the court in connection with the TPO?
Yes.
And as a result, when you went back to court, did you obtain an extension of the TPO?
Yes.
Okay. Showing now Defense Counsel States Exhibit 7. And may I approach?
You may.
Ma'am, I'm not going to show you what's in the pre-marked States Exhibit 7. Do you recognize this document?
Yes.
How do you recognize it?
This was the extended protective order.
Okay. And does that appear to be a fair and accurate copy of the order that you received after you went back to the court?
Yes.
Okay. And reviewing it, review every page there. You don't have to read every line, but just make sure that there's not been any additions, alterations. Yes or no?
No, nothing has changed.
Your Honor, this time state would move to tender into evidence States Exhibit 7.
Ms. Wood, subject to the objections that have been raised and preserved during the time the jury was outside of the courtroom, any objections beyond those to the admission of State 7?
We just renew those and otherwise that's.
Okay, they are renewed and not waived. It's admitted.
Thank you, Judge. Ms. Thomas, I'm just going to briefly direct your attention to paragraph 3 in States Exhibit 7. What are the dates there?
7/22/2021 until 7/21/2024.
And how did it make you feel knowing that you had an extension of that TPO?
It was freeing.
And how does it feel to be here today testifying?
I was afraid, slightly embarrassed. You don't necessarily want people to know what you go through. But slightly vindicated to be able to talk about it.
Nothing further.
Did you have any recross?
Nothing further, Judge.
All right, so we're gonna try again. Ladies and gentlemen, if you've got any questions, feel free to write them down. If they've already been written down, if you could just guide Deputy Gordon to the right pile, because there are a bunch of piles there. We don't want to miss anything. All right, and next time, just hold on to yours and then we'll pass them down when there's collection time. It's like church, we just don't have the little offering bowl. Same kind of thing, you're welcome. If you want to give Deputy Gordon a tip. Thank you. Not really, they overpay sheriff's deputies. Yes. Yeah. I just- Okay, if I could have the lawyers, we'll be right back, so I have to talk with them about the question. Press the little black button. Don't pull the blue thing. There you go. All right, Ms. Thomas, we have a few more questions. Thanks for your patience. Could you clear up for us? There's some confusion. Your son's birthday party with the cooler and the bouncy house and the game truck, was that in April of 2020 or April of 2021? In other words, last year or 2 years ago?
Not last year, the year before.
So you think it was in April of 2020?
Yeah.
Okay. You described to the jury some prior incidents, encounters you had with Mr. Bryant that were violent. Can you explain to the jurors why you didn't report those to the police, or if you did, tell the jurors what happened there?
There have been times that I had reported things to the police, and then I would always kind of recant, but just out of fear of, not having, I guess, his support around, I guess, for watching my kids when I'm working, or just being in a kind of a mind space of, if it's happening so often, why do you continue to stay, or why do you continue to go back? Just kind of felt I was in a place where I just didn't feel like I could do it on my own. So, my well-being was sacrificed for that, for me being weak and not having much confidence in my ability to provide for my children.
So, Ms. Thomas, at some point, because of the TPO that you obtained against Mr. Bryant, he had to move out of the Sir Henry address.
Yes.
After that happened, how often did your three kids spend time with Mr. Bryant?
They did not.
Because they were part of the TPO?
Yes.
Okay. And when you all were living together pre-TPO, even though you and Mr. Bryant may have been separated in the sense that you had your room and he had his room, would he regularly interact with the kids?
Far and few and in between. The kids kind of stayed in their areas. Like Liz would kind of hang out in her room. Bryce hangs out in his room, and the same thing for Olivia.
Okay. Can you share with the jury why you, I think you said that the term was dismissed. You sought a divorce originally, and maybe it was in 2018 from Mr. Bryant, but that didn't go through. And I think the term I'm remembering was you said the divorce was dismissed.
Mm-hmm.
Don't worry about the term. Just explain to the jurors what happened with that first divorce.
First divorce, if something happened with the filings, they had written the case numbers down incorrectly. So when we went back to court, they didn't have the evidence didn't match up because the case number was not entered correctly. So they dismissed it. So I had to refile.
I'll talk a little bit more about mail coming to Sir Henry after the TPO. If mail arrived, because Mr. Bryant only knew he had to get out of Sir Henry after the judge entered the order. So mail would have been coming from Mr. Bryant to that address for a little while before maybe he did a change of address, maybe he didn't. That's his business. How did you make sure that mail for Mr. Bryant that came to the Sir Henry address got to him?
I didn't, because I wasn't allowed to have any contact. He could have, I assume, had his parents, his mother or father reach out, but no one ever did.
Okay, so there's mail that got sent to Sir Henry that in theory, Mr. Bryant just never got.
I assume so, yes.
Okay.
That makes sense.
You answered some questions about a temporary protective order that Mr. Bryant obtained against you, requiring you to stay away from him. Tell the jurors, maybe again, but tell the jurors how you learned that there was a TPO against you.
I learned by that I was at work, my children were home. I never received a document, but there were the sheriffs at the 3286 Sir Henry Street address. They were knocking on the door. My children went down. I told them to go ahead and open the door. They opened the door, and I spoke to the sheriff that was on the other end. And he informed me that Mr. Bryant had taken out a restraining order. And I questioned it because I'm like, I didn't understand, because there was already a restraining order in place for him. But this
Ballpark.
was- And he had been out of the home for, I had not seen him in a year's time. So I don't understand, there wasn't any interaction between the time he filed his and when mine was filed.
This time when the sheriff came to your house, but you were at work and the kids put the sheriff on the phone with you, was that before or after the birthday party incident?
That was before. the
Okay.
birthday party.
And your testimony is that the sheriff's people did not leave any paperwork with your kids.
They did not.
Have you ever seen the actual restraining order?
I have not.
Did you play any role in making sure that Mr. Bryant received a copy of the TPO that you got? In other words, you got one taken out for you and your kids that said, Mr. Bryant, stay away. And the jurors have seen it. It also said, stay away from Sir Henry. Did you have a role in making sure Mr. Bryant got a copy of that TPO? Or is that someone else's job?
Yeah, what do you mean?
Did you hand it to him? Did you mail it to him?
No, I didn't. I did
Okay.
not.
Did
We
you,
were in court. I do believe Judge Manning issued him his copy, I do believe,
okay.
because we were there at the same time.
It was not your job to mail it to him, however it got to him. Okay. So when you obtained that TPO, it was at a hearing and Mr. Bryant was present for that hearing.
Yes.
I want to talk a little bit more about the birthday party incident. Can you tell the jurors where in the house you were when your daughter and Mr. Bryant were having their exchange about the cooler and whatnot?
I do believe I was in my bedroom calling cops.
Okay, and your bedroom is on the same floor or a different floor?
On a different floor. My bedroom is downstairs. Hers is upstairs.
Okay, so you were downstairs?
Yes,
Okay, and where was the cooler where they were having the argument, upstairs or downstairs?
downstairs.
Okay, so you were on the same floor?
Yes,
Okay, could you see them while the argument was happening or just hear it?
I could just hear it.
How many times did you call 911 the day of the birthday party incident?
Once.
Okay. Do you know if anyone else in your household called 911?
Well, when I called 911, they did say that the cops were already en route, so I would assume that someone else there called as well.
Okay, you don't know, fair assumption, but you haven't talked to someone and said, oh, wait, you called 911 as well.
No.
Okay, all right. Mr. Whitenauer, do you have any questions that are follow-ons to those questions from the jurors?
Yes. Ms. Thomas, were you confused about the question when you were asked the question about the date of the birthday party?
Yeah, I had to think back.
Okay.
I had to think back.
Have you had an opportunity to think back about that date now?
Yeah.
Okay. If you were able to review the police report, would that help refresh your recollection of the date?
If I had to.
If you could review the police report, would it help refresh your recollection of the date?
Sure.
All right. May I approach?
You may.
All right, I'm showing you a copy of the police report. If you'd like to review that, and to refresh your recollection, and if it does, just look up and then I'll ask you a question. Okay, and reviewing that police report, has your recollection regarding the date of the incident been refreshed?
Yes,
Okay, was it in 2020 or 2021?
21.
Is it hard for you to remember all the different times that there have been assaults by Mr. Bryant and issues with Mr. Bryant?
I didn't hear you.
Is it hard for you to remember all the different times that there have been assaults and issues with Mr. Bryant?
Yes.
All right. You were asked about service of the TPO, of the TPO, which you were the petitioner, and Mr. Bryant is the respondent in State's Exhibit 6. Do you remember that?
Yes.
About service and about whether you mailed it to him? Do you remember that question from the judge?
Yes.
Okay.
You're not a sheriff's deputy, are you?
No,
Okay. You're not a process server, are you?
no.
Do you know what a process server is?
Sounds like someone who maybe serves someone.
Okay, all right. And this 12-month protective order, can you just read to the jury the first sentence under its title there, beginning with a hearing?
A hearing was held on this matter on June 19, 2020, for which the respondent had notice as required by law, at which the respondent appeared and or had the opportunity to.
Can you not tear the paper right now? Thank you. Tough timing. Keep going.
I'm sorry. I don't know where I was. Having heard the evidence presented, reviewed the petition and the entire record concerning the case and for good cause shown, it is hereby ordered and judged.
Nothing further. Thank you.
Ms. Wood, do you have any follow-up for Ms. Thomas based on the jurors' questions?
Nothing further, Judge.
All right, Ms. Thomas, thank you for your testimony. You are free to step down.
Thank you.
Mr. Whitenauer, next witness.
That would be handled by ADA Green.
Ms. Green, are you guys going like every other?
We're at every other judge.
All right. Mr. Hand is looking longingly at maybe having a witness.
We like Mr. Hand. Support that.
Yeah, he's window dressing. All right. Ms. Green, next witness.
Officer Clervo.
Yeah, okay. Yeah.
Where's Bryant? State so nice and right.
Officer Benito Clervo. Benito, Benito.
Officer Clervo, where are you employed?
I'm employed with the city of East Point.
Right? And how long have you been there?
I've been there 2.5 years.
What's your title?
I'm a police officer.
Okay, and is there a particular unit that you work on?
Patrol.
And how long have you been patrolling for East Point?
2.5 years.
And is that the length of time you've been with East Point Police as well?
Yes.
And on April 30th, 2021, what capacity were you in?
I was a police officer.
Okay, and were you on patrol that day?
Yes.
And do you recall responding to the address of 3286 Sir Henry Street, East Point?
Yes.
All right, and how do you recall, what made you respond to that area?
The call came over the radio as a 2958. That's a fight, domestic related.
Okay.
When I arrived on scene, I witnessed a black male and 2 black females, one a juvenile. The black male was later identified as Stuart Bryant.
Did you make contact with Stuart Bryant?
I initially made contact with the adult female
Okay.
who was Malika Thomas.
Okay, okay. We could start with Ms. Thomas. So you made contact with Ms. Thomas. Were you the only officer on scene?
At the time, yes.
Okay. Did other officers arrive?
Yes.
And who were those officers?
Sergeant Broussard and Officer Reeves.
Okay. You made contact with Malika Thomas, and what happened next after you made contact with her?
All right. As I walked towards the door, it was Stuart Bryant and Malika Thomas and their younger daughter at the time, Elizabeth Bryant. I noticed Elizabeth shaking frantically. So I went to ask Malika what happened, and she stated,
What did you,
Hold on one sec.
I can guide that, Judge.
Okay, but let me just, so they don't have to object again. Officer Clervo, you're doing a fine job fielding these questions. But make sure, unless a lawyer says, what did the person say next? You don't get into what someone said.
Gotcha.
Just describe what you did and whatnot. It may be appropriate sometimes, but generally we need to get that person to do the same. Okay, thank you.
After you spoke with Ms. Thomas, what did you learn?
after I spoke with Ms. Thomas, I learned that there was a verbal altercation between the two parties.
And what two parties are those?
This is Stuart Bryant and Malika Thomas.
Okay. And did you identify who Stuart Bryant was at that scene?
Yes.
And is he in the courtroom today?
Yes.
All right. If you could just describe a piece of clothing.
I believe he's wearing a navy blue long sleeve shirt.
Okay. And Judge, let the record reflect that Officer Clervo just identified the defendant.
He has, it will.
Thank you. Right, you learned from Ms. Thomas that there was an altercation between her, Ms. Thomas, and Mr. Stuart Bryant, right?
Right.
What'd you do next?
After I learned that there was a verbal altercation between the two, Mr. Bryant then got verbally aggressive towards Ms. Thomas. That way I split the two apart. I had Mr. Bryant walk down towards my partner who had just arrived on scene.
And who was that?
That was Officer Reeves.
Okay.
And I then spoke with Ms. Thomas alone.
Okay. All right. Have you handled domestic calls previously?
Yes.
Okay. About how many domestic calls would you say you have handled in the past?
In East Point, we have those calls quite frequently.
Okay, give me
I'm gonna say 100.
100. Okay. So by this point, you had handled about 100 domestic calls?
Yes.
And so when you're arriving to a scene knowing that it is a domestic call, is there a particular protocol that you're to follow?
Yes.
Okay, and what is that?
Once we get on scene, we divide the two apart, one with the partner and the other with the other party, keeping a close eye on each other. And we'll question one party and then question the other party.
Okay.
On what took place.
Okay. And is that what you did here?
Yes.
Okay. So you separated the two parties, like you said. What'd you do next?
After separating the two, I asked Ms. Thomas what took place.
And so after speaking with Ms. Thomas, what did you learn?
I learned that Mr. Bryant had tipped over the ice cooler that was in the house or the backyard. I'm not quite sure. Then he called Miss.
Calls for hearsay as well.
Okay, right. It's sort of you're doing fine again, answering the questions that are being posed to you, but it's sort of an end around question. So let's ask a different question.
So after speaking with Ms. Thomas and you learned there was an altercation, Did you learn anything else regarding the domestic relationship? Did you learn what relationship Ms. Thomas was to Mr. Bryant?
Yes, they were going through a divorce.
Okay.
She just filed a TPO out on Mr. Bryant.
Okay. And have you been trained in domestic calls on how to handle instances where there's a TPO involved?
Yes.
What is the protocol when there's a TPO in place?
When there's a TPO in place, we would read the TPO verbatim to the defending party and make sure that they understand each line
Okay.
on that TPO.
Okay. And when do you do that part?
Once the TPO is presented to me.
So when it's given to them?
Yes.
When you're responding to an instance where a TPO is already in place, what is the protocol in that instance?
Repeat the question.
So once you're responding to a domestic call and you learn that there's a TPO in place, like in this instance, what is the protocol that you're to follow?
Well, normally I would contact my supervisor and have them arrive on scene and to just go over the TPO after I've looked at the TPO.
Okay. Okay. Did you make contact? And did you do that here in this situation?
Yes.
Okay. You did contact your supervisor?
Yes. Well, he was already en route.
Okay. And who was that person?
That was Sergeant Broussard.
Okay. And did you make contact after you did that? Did you make contact with anybody else at the scene?
I spoke to who was Elizabeth Bryant, who was a juvenile at the time.
Okay. And after speaking with Miss Bryant, what did you do?
After speaking with her, I was waiting on my sergeant to come back with the TPO because before I spoke to her, he had taken the TPO to confirm that there was an active TPO out on.
Objection, Your Honor. I believe this also calls for hearsay, and if we're going to continue down this line of question, we may need to take it outside the presence of the jury. What his sergeant is telling him about the TPO.
Oh, okay. If it's limited to confirmation that some system says it's active, that's not being offered necessarily for the truth of the matter asserted as it is to explain what the officers would do in receipt of that information. I don't see the issue, but if you think it's going beyond merely confirmation, then I'm happy to pause so we can do that. But I would ask that we keep it to confirmation. The TPO speaks best to what the TPO says, and it's in evidence. Okay.
So let me just make sure I got down what you did in the order that you did it, based on your testimony. You made contact with Ms. Thomas, correct?
Correct.
You reached out to your supervisor for him to come to the scene?
Correct.
Okay. And then you made contact with the minor, Elizabeth Bryant?
Yes.
Okay. What, if anything, did you notice about Elizabeth Bryant?
Elizabeth was shaking frantically as if she was in a fight with someone. I did notice she did have a broken fingernail.
And did you learn as to how that occurred?
Yes.
How did that occur?
She stated she was pushed down to the ground.
Objection, hearsay, bolstering.
Sustained on both grounds, but certainly hearsay.
And did you take any photographs in relation to her injury?
I believe I took pictures. I can't recall.
And on that day, were you also in uniform?
Yes, ma'am.
Okay, and is your uniform equipped with body worn camera?
Yes.
Okay. And have you had an opportunity to review that body worn camera?
Yes.
Your Honor, may I approach?
Yes.
What did I just hand you?
Yeah.
What did I just show you?
A CD with the incident that took place on that day.
Does that have your body worn camera on it?
Yes.
Have you had an opportunity to review it?
Yes.
And how have you identified that you reviewed that body worn camera on that disc?
I initialed it and dated it with my badge number.
In reviewing the body worn camera, has there been any alterations or deletions to the scene as it was depicted on that day?
No.
Okay. At this time, the state moves to enter in State's Exhibit 8.
Any objection to States 8?
No objection, Judge.
States 8 is admitted.
And Your Honor, now the state moves to publish.
Any objection to the publishing of Exhibit 8?
No objection, Judge.
All right, it may be published.
Turn right onto Greenway, then turn left onto Calvin. Turn left onto Calvin Court, then turn right onto Sir Henry Street. Turn right onto Sir Henry Street, then your destination.
2687.
Your destination is on the left.
Ms. Green, does this get to where we need to be fairly quickly, or is this like a half hour of driving?
No,
I was gonna last month and she wanted it, so I'm not. I got paperwork showing that she got served yesterday. I was coming to check my house. And it's COVID, so I'm not gonna get too close.
I'm the mother. I filed a restraining order against
Which
this man.
ended in March 3rd. Hold on, man. Wait. I'm about to show you one that's updated. All right.
June, it says June 18th.
Yeah, but it's been that one was back in March 3rd. It ended March 3rd. This one here is recent. I just filed this one last month, and she should have been removed yesterday. The police came here yesterday. I don't even know why.
Did you have a copy of that?
Huh? Say what?
Where is that?
I haven't been down there to get it yet. But they sent me this one.
Was it served?
Yeah, she got served.
I did
She
not
got
get
served
served. I was at work. I was
police officer?
not served. I was not served. I was not served.
Well, my thing is, I got a notification that that the police were here yesterday, so I was under the impression because we don't have contact
of Fulton County.
Yeah, I got
You all
Superior
can.
Court
I'm
as well.
gonna keep this one. And you all have
I
that
saw
one.
this the last time I was
The
out
same. No, I had copies made, but these are the same.
Cavity in your mind. Jesus.
Hey, come on, man.
Thank you.
Over there. Go over there.
Petitioner, which is me, is awarded sole exclusive possession of this residence.
Over there, sir.
Thank you, sir. Until this said date.
And this was served?
Yes, sir.
Broke my nails.
What happened in the house?
I'm having a birthday party for his son. My son, he hasn't seen his kids in a year, and he comes in dumps out the ice cooler saying it's his. I got to get out of his house, and I have these documents. I don't have to go anywhere.
But what happened to her?
He smacked me and my nails broke. I just got these done and I just
That's his child. Coming in, cursing us, calling us bitches, telling us to get the fuck out. I got a backyard full of children.
It's my brother's birthday party and
2021.
I remember because he came over here last time to get property.
And I do remember you.
he's taunting my mom. Like you just heard, he said she has something in her mouth, and I smacked.
And it's my son's birthday. Got the gamer's truck outside for my boy, a water slide in the backyard full of kids.
He doesn't even have a license. I don't know how he got over here.
License, right.
Take him away. He
had to come here.
27, confirm you at Marketplace Boulevard and
Bryant. What's his birthday?
October 76.
October 31, 76. Let me check to see if it's on GCIC. If it is, then we'll go.
Can I go back and tend to the children, or do I need to stay out here?
Just stay right here for a little bit.
Sorry, will you do me a favor? That meat, if maybe some empty pants, maybe pull it off. I got some more to go on there. Thank you. Are your pants dry? You got it on the bangle. Yeah, you dry. You going to the game here? Yeah, I'm taking the game. Try it out. Get them out of Granny. Good money, spirit.
Thank you, Granny. Oh my God. I was stupid.
Is that your dad?
Yeah.
And her dad and my son's dad, he was married, was still currently married. I filed for a divorce. They dismissed it because the cops who did it wrote I have all of that paperwork, he worked the case number down, so they dismissed it. So unfortunately, still married, still going through this shit. Excuse my language. It makes no sense, and I can't believe that he is this brazen to come in here and disrupt his own son's 12th birthday. Didn't send him a card, didn't get him shit, ain't did nothing for these children in a year. It's been all on me and these 3 kids. My son has autism. My daughter was cutting herself because of this man. You know what I mean? Oh my God.
It's the same paperwork my son got?
Same paperwork. I made several copies. What about it? And from what I'm understanding, when we went to court, he's not allowed to pull up a restraining order on me when I have one on him for family violence. I can bring you that whole packet of how he has beaten, how he has bad talk, how he has degraded and demeaned his children. His house is in foreclosure, and you want to come try to put me and these children out, and they're your fees just for the sake of me being homeless? I can take care of mine. You can put us out today. We'll have somewhere to stay.
But you don't have that right.
But absolutely. On the deed. And you can't put me out. I'm not on the mortgage, but mine is showing up on that deed. You can't do anything with this property without me. I really cannot believe this.
Can you pause it? And who is that right there in your body cam approaching?
That is Sergeant Broussard.
Is that the supervisor you mentioned?
Yes, ma'am.
Okay.
I understand. 19, put your hand on
Put your hands on your back.
Are you free?
Yes. No, you were served with that order. You were served with that order. okay? You were served with that order, and it's also on the state system, okay? So,
Was it not?
ma'am, I want to ask you again,
Can I just show you something, please?
boss,
Sir, can I just show you something?
boss, you probably should have did like you did last time when you came to get property. Remember when you came to get property? I was here.
Can I put my property in the reference properly?
No, you're going to
No,
jail,
I understand.
and you're gonna get charged with aggravated stalking on the family violence.
Are you kidding me? Because
No.
it's been over with.
No, it ain't over with. It's still active.
I have a knife in my pocket because I carry now.
That's fine.
Go ahead. Wow.
You have any medical conditions at all?
Put it in the front. In the front.
You have any medical conditions at all?
Can I get my?
Diabetes, epilepsy, high blood pressure, anything like that? Yeah, we'll put it on.
Stolen on a 2010 Nissan Altima black in color, valid.
You're taking me to jail. This is amazing. This is amazing.
Boss, the best thing that I can tell you, when you go to court, you may want to hire an attorney so that we can get this straightened out. This is amazing. Can I make a phone call?
That tag is one that was stolen on a.
You on the other side, sir?
Where is he? I would. Wow. This is amazing. This is amazing.
Have a seat.
Even though the TPO was over with, son,
It's not over. Have a seat.
it was 12 months. I'm not fighting you. I'm just asking. It was 12 months. I'm not. Slide in. I cannot.
And what is happening right there? You placing him in the vehicle? What's happening?
As I'm placing him in the vehicle, he's questioning Sarge about the TPO that
What'd he say?
even though it was 12 months.
I can't even talk to you. You all talk to her.
Man.
Please, my God,
I read the paperwork.
but it says 12 months.
Slide in.
Sir, it said 12 months. Wow. It says 12. Please.
Watch your foot. Watch your foot.
Listen. Can I just talk to you? Come on.
You gonna talk?
Can I talk to you?
So at this time, is the defendant under arrest?
Yes,
Okay. And what was he charged with?
he was charged with aggravated stalking and simple battery family violence
And why was he charged with simple battery family violence?
for pushing his daughter down to the ground, causing her to break a nail.
And who is that daughter?
That is Elizabeth Bryant.
Right. Thank you. No further questions at this time.
Ms. Feely?
Officer, you didn't have anything to do with the TPO being taken out itself, right?
No,
And you didn't have any involvement with the serving of the TPO.
no,
Your only involvement was responding to this particular fight, domestic
Yes.
call.
yes.
And you don't have experience serving TPOs in general, right?
I've served a couple TPOs.
So if you've served TPOs before, you know you document when you serve them, right?
Right,
And I think you actually said that you read the TPO to the person,
right,
and that's standard operating procedure.
right,
And that's how you would do it,
Right.
right? And then you would document that you served the person.
Right.
And you would file something with some court of record.
right.
And in this particular case, that wasn't your role, though.
That is correct.
Thank you.
Green, anything else?
No further questions, Judge.
Jurors, any questions for Officer Clervo? Got a few? Okay, take your time. If you need to write anything else down, Deputy Gordon will collect them. Yeah, that's good. Thank you. Counsel? Not on the door, it's on the side. Little guy right there. Officer, did you check to see if the TPO that Mr. Bryant said he had obtained, he didn't have a paper one, he was saying it was on his phone. Remember that interaction you had?
Yeah.
Did you ever check to see if there was such a TPO in whatever system was checked concerning the paper one that you did get from Ms. Thomas?
No.
Okay. Do you know if any, it looked like there were a couple other officers at the scene. One was your sergeant, maybe one other gentleman. Do you know if they ever checked to see if there was a competing TPO in the system?
No.
Okay. Any follow-up, Ms. Green?
No.
Ms. Feely? Officer, thank you for your time. You're free to go. Your next witness, I'm guessing if you're going to call him, would be Sergeant Broussard.
It would be, and the body cam alone would take us past 5.
Okay. I think we're at a natural break point, but before anyone starts stirring, is that your final witness as you forecast it right now?
Yes, for the state's case in chief.
Okay. And you would expect the sergeant's testimony from the state side to last, including the body cam video?
40 minutes.
Okay. We'll call it an hour. Are you the sergeant?
Yes, sir, I am.
All right. Nice to meet you. We will meet you more formally tomorrow.
Okay.
Sorry that you had to be here today as well. They'll let you know when you need to be back here tomorrow, but I can give you a preview. We're starting at 10 tomorrow.
I'll be here at 9:45.
Perfect. And if you see any stray jurors, pick them up and get them here by then too.
I can't transport because I got an 84-pound mallet on the back.
All right. Nor could you transport them even if they ask for help because they're jurors. All right. Thank you, Sergeant. We'll see you tomorrow.
Stand by.
All right. So your expectation is that you'll rest in your case in chief when you're done with the sergeant's testimony.
Yes, Jen.
Okay. And then Ms. Wood, we'll talk after the jury's gone for the day about your expectations for a defense case. But it sounds like, ladies and gentlemen, you'll be getting the case for your consideration, meaning deliberations tomorrow. The state will rest. We'll see if there is a defense presentation. They don't have to present anything, but they're entitled to. They have the power to call witnesses and get people on the stand and tender exhibits if that's what they want to do. If the state doesn't put on any evidence, then the evidence is closed. If they do call one or more witnesses, the state has the possibility of rebutting by calling either a witness who's already testified to come on back or a different witness. The rebuttal case is usually pretty short if it happens. Then the lawyers would give their closing arguments and then I'll charge you. That's all going to fit into tomorrow. So you'll begin your deliberations tomorrow, probably after lunch, because we can't start till 10. I know it'll be after lunch because we can't start until 10 tomorrow. But you will be getting the case sometime in the afternoon. As of now, all the weather reports I've read are that it's safe to move around Atlanta tomorrow. I will not make you be here if it's not safe to be here. Although frankly, right here is one of the safest places to be when it's rainy and windy. The issue would then be getting home. And I'm not going to put you out on the roads when it's unsafe either. But all the reports I'm getting is that we're going to be relatively okay. And certainly okay enough for you to be here tomorrow. If we start getting word it's time to shut down at noon, even though we're not done, we'll send you home at noon and we'll get back in here when we can. But right now the outlook is that it will be okay for folks to be here. Any logistical questions? Please, no outside research. You have demonstrated by, I think we're on card number 29, that you're able to ask questions. Some of your questions were not asked and thus not answered. They just weren't legally appropriate questions. That's not a license to get online and look something up or to talk to a friend or a roommate or someone you don't even know online trying to get an answer to something. The answer would need to come here in the courtroom. So with those instructions about no outside research and really not talking about the case with others, If there are no questions, you all are free to go. Thank you for giving us the day. What time are you going to be here tomorrow? Yes. Hey, be like the sergeant. 9:45. You all can be seated. So my homework tonight is to go over the draft jury charge that Ms. Niles has put together. And I will email that to all of you once I'm done with it. And we will have our charge conference, at least our preliminary charge conference tomorrow morning before we get started with the jurors. I'd ask you all to be here by 9:30, and we'll try to knock out the charge conference between 9:30 and 10. Let me look at one thing from Ms. Niles. All right, there'll be some things I need to work through and ask you about in the morning. In particular, there's some charges about a family violence order, which is not what I think is in place here, but you all can educate me about that. These are state's requests to charge, and they puzzled Ms. Niles, and they're puzzling me superficially. I haven't dived into it yet, but that's different from, I think, a TPO. But either way, we'll work through that. And I also want to understand if we're going to need all of those charges about a defendant's custodial statement, especially if Miranda is involved. And I'm assuming what gave you pause and prompted you to submit all those charges about a defendant's statement would be from Broussard's body cam, because what I heard from Clervo's, other than Mr. Bryant asking or saying repeatedly, well, it was only 12 months. First of all, there was no interrogation. But second, it was the same, like, oh man, or oh wow, and it was only 12 months. So I don't know that we need to instruct the jury ad nauseum about the voluntariness of a statement.
I don't think so either, Judge. I guess it was out of abundance of caution. We hadn't addressed Jackson Deno.
Yep, and always a safe thing to do. And we may need to talk about that not only during the charge conference, but after Sergeant Broussard testifies, because then I'll have heard the body cam video. I'll note that I haven't heard anything from the defense prophylactically saying, wait a minute, there's an issue with the body cam. Sounds like they're not going to object to it coming in. But it may be that in the end, you want me to make a finding that whatever is on the camera that constitutes a statement of Mr. Bryant, it was freely and voluntarily given, either because it was spontaneously uttered, it wasn't in response to questions or whatnot. And we can do that. I don't know that that will yield any jury charges, but we may need to make a record of that if it's something you're going to want to rely on in your closing. Anything else from the state?
No, Judge.
Okay, Ms. Wood, anything else? All right, so if you all could be here at 9:30, including Mr. Bryant, and Ms. Bassett, Ms. Evans are free to be here tomorrow as well. We'll do the charge conference, and I am confident Sergeant Broussard is going to be here on time. Didn't leave any doubt about that. And so as close to 10 as we can get all our jurors and finish up with the charge conference, we will have him take the stand. At noon tomorrow, we'll need to take the lunch break kind of close to noon. There's a special grand jury thing that I need to take up. It won't take very long, and I'm happy to make people wait for a little bit. But if the flow is, gosh, it would be a whole lot better to break at 12:45 for lunch. We probably aren't going to break for lunch at 12:45. It'll be closer to noon, just FYI. And that's it. Thank you, everyone. And I will see you at 9:30 tomorrow.
Judge, may I approach about a non-case written matter?
You may.
I just wanted to apologize.
apologize. I think probably during counter call and yesterday during jury selection was probably a little bit short in some of my responses. I don't think I was probably rude, but been burning it both ends of the candle with a couple of top founders and family. So I'm sorry.
Not a problem. Didn't see it that way. Great. Oh yeah, if any of you has any exhibits, make sure they're getting to Ms. Rivers as the official keeper of exhibit, meaning exhibits that have been admitted.
You have all eight of them? Or is it? Yeah. Yes.
Finally, this is the first. Six, 4, 8 months. They full household. There's one that,
Yeah. Oh, you did? Okay, great. You got it? Okay. Thank you. Thank you, Judge.
You're welcome. See you tomorrow.
Huh? I was starving. I feel like no one else is hungry but me.
chips.
And she said, I didn't totally understand. She said, we'll wait. I know she meant by that.
Oh, that's
So, but she also did say you have a full picture.
Oh, that's you, right?
That's not sure.
She also didn't say you have a full picture. Yeah.
Oh, well, wait, wait.
Yeah, I was like, so just for nothing. I don't understand.
All right, see you on the morning.
I don't know if she told him to, but he did accept it, so I seen.
So I still gotta handle it.
Yeah. No, it was fine, but I was kind of annoyed, I was like, also, the two phones on here. Is that your
Yeah, thanks.
No. Okay.
HP. That you bring it up. Are you going to get charges back to Frank?
Yeah, I'll go, I'll drop it off. Yeah.
I'll forget, it's okay.
Makes you grow like a smart person. Person you didn't want to say.
Yeah, I. Just do it, that's, yeah, thank you for checking. Thanks, Rivers, tomorrow. Bye, everyone. Have a good one. Thank you so much.
Okay. Because there's no way for her to get it up there unless. But did he have one? Well, I don't understand how he got one. Because her ass right. But what did he allege? Like, if she hadn't seen him a whole year, what did he go to say that she did to him in order for him to get it taken care of? They certified to him. But did he have one? There is one. Or did he have a petition? So yes, he came and he filed. Did he get in her house? But she technically wasn't served because they can't serve the kids. So she was supposed to have been aware of it. But that's not proper service. So when he went back to court, does the same thing Ms. Philly asked all those questions? So that's crazy. You know, she was about 16 at the time. And that's the situation she was. That's all I have to say. My dad. She's probably. And she said it all came worse back to her. You have to see it to say. It's okay, we don't do that. So I'll give you what they do. Make them go try, keep them on probation. You know, because that's his process. But he let them come in That's all right. It's not what he was. Can't go on back. She embarrassed. You know. He made his office. He's an electrician. No, I got a lawyer. Ask an electrician. Who's on what's on his side? Okay. You know, sometimes I really be terrified of it. They probably can't do it. They don't even say happy birthday. He makes me proud of it. Because he got since she thought she was broken now. You ever had all of the thing on acrylic gels? It is fresh. The fact that you pushed that. Like, she just kind of disrespectful. So she, because when you show her, because she still had manners. She ain't old, but she don't have no respect for you because she doesn't say me how you trying to come up. This is the family problem. People want to catch up with the petition, so this case will 5 months before you get it.
I see you, Mom.
All right. See you tomorrow.
Hmm.